I get your lordship kind leave to move one very urgent tender motion, lordship, tomorrow, lordship. The urgency is that, lordship, the financial bill evaluation sheet was published on 25th April, last Tuesday at 5 p.m., lordship. And work order has been issued with effect, which will be effected from 1st May, Monday morning, lordship. Lordship, kindly take up this matter tomorrow, lordship.
Yes, leave granted.
Lordship, I have a similar prayer against the same work order, my lord.
When is the work order going to be issued?
1st May,
Sure.
it will be given effect to, my lord. They will be start
First?
1st May, on Monday onwards. They will start working, my lord. We have given representation.
Yes, tomorrow. Leave granted, yes.
My lord, may I permit to mention item 56, my lord, but the interim order will expire on 30th April, my lord.
Yes, to be mentioned tomorrow.
May-
Motion, my lord.
Wait, yes.
May your lordship permit me to mention that my clients are the bona fide businessmen within the station compound and with having documents, and the railway authority has served.
No, I will not see. Just tell me the facts,
My lord,
please.
item number 198 for the day's list.
No, what is the urgency?
Unless my lord kindly go.
No. What is the urgency?
Urgency is they will be evicted within 1st May 2000.
When did you get the notice?
My lord, yes, this is the notice. My
When
lord.
did you get the notice?
Yeah, 24th itself, instant. My lord, kindly protect my client.
24th.
The petition
24th
is
of which
20
month?
24th April, my lord. My lord,
24th
kindly
you,
protect
24th you got the, please.
some extent, my lord.
Don't hand up documents. I will not upgrade the matter. Please follow the questions. 24th you got the notice that you will be evicted on?
1st May of the.
1st May.
Yes.
Very well. Tomorrow.
Unless.
Tomorrow.
My lord, may I have your lordship's kind leave to mention item number 208. My lord, KMD is not executing a deed of lease in my favor. My lord, I won't be able to obtain bank finance until unless I mortgage my leasehold rights. My lordship directed them to consider my representation in July 2022. I filed the writ petition in August 2022. My lord, I need some bank finance to run the educational institution. Item
Yes,
206.
yes, 10th May.
May I have my lord's kindly
Notice
to
to the other
mention
side.
item number 177, my lord. It's a tender matter, my lord. I have challenged, my lord, the inaction on the part of the authority in opening the financial bid. My lord, day before yesterday, we have, my lord, received information that they are going to, my lord, scrap this tender process and my lord, go on with a new
When?
tender process.
When?
Day before yesterday,
No. When will they do it?
my lord, the date is not known, but this process, my lord, where I had participated with 2 other bidders, that would be
Very well.
scrapped.
8th May. Notice to the other side.
I am grateful, my lord.
My lord, I'm mentioning one matter, my lord. This matter was mentioned before your lordship on 3rd of April 23, my lord. And your lordship directed that the matter would appear in the list in the 4th week of April, my lord. My lord, but this is with regard to my lord bank. In spite of payment of amount, my lord, bank is not releasing my original documents.
Very well. On 8th May. Notice to the other side.
My lord, may I permit to mention item number 87 of today's list. By order dated 20th of March 2023, your lordship directed the administrative general and official trustee to make an inventory in presence of the petitioner and petitioner's daughter, because the large number of antiques were removed from my home without any jurisdiction. Now, my lord, there's a direction by 28th March that has to be completed. They have not done it. On 3 days, I have been called, and every day they are misbehaving. On the last occasion, that is on 24th April,
Who is they?
my lord, the administrative general and official trustee and his officials. My lord, they are misbehaving so miserably. My lord, I have taken a photograph that the antique items were so mishandled. I have taken a photograph, and he said that you have to give an apology letter. I'm calling the police.
Very well. What is the last date when all this happened?
24th of April.
24th of April. When did you file the writ petition?
The writ-
Or is it pending consideration?
Yes, item 87, it is listed. It is in the list.
Very well. 3rd May.
Grateful, my
With all due apology, my lord, may I seek for deepest of indulgences? My lord, yesterday, the railway matter was taken up, my lord, in which Mr. Shah was appearing,
Yes.
and the matter is fixed on Monday. My lord,
Is your other side?
yes,
ready?
I was mentioning upon notice, my lord.
Yes.
Instead of Monday, I am praying, my lord, Wednesday, if my lord kindly considers this. Because for this simple reason, my lord, there is a person who is affirming, my lord, has got certain medical emergency, has to leave Calcutta. So, my lord, I have to file an affidavit. I am praying up to Wednesday, my lord. This is the only.
If your lordship permits, my lord, we can proceed, my lord, on the basis of an unaffirmed copy, my lord. They can affirm it and file it later.
Very well. Mr. Ray, do that. You don't need an affirmed affidavit.
Very good.
You can proceed, or Mr. Shah can also proceed. Just give them an advance copy.
I'm
All
re-
right. Because the affidavit was not required. It was only because you
Yes, yes,
requested.
that's why
allowed
I
it.
wanted to bring
So
some
you can,
document.
you don't
Instead
have to
of that,
affirm it.
my lord, then kindly give me the liberty, my lord. I will be handing 1 or 2 documents, my lord. It may, so that, my lord, that can be taken out. The affidavit will be affirmed on by Wednesday, my lord. That's kindly give me that liberty. Instead
One
of,
or two documents
my lord, in the affidavit.
in the
my-
affidavit,
in the-
advance, give them an advance copy so that they have a copy by
Yes, yes.
Monday. By
Yes,
Monday.
yes, by Monday they will have the copy.
Very
Definitely.
Yes,
Great.
very well. Yes.
My lord, with regard to, my lord, the
May I, my lord, take this my lord, opportunity of mentioning, my lord, the matter, my lord, filed by, my lord, the NCLT Advocates Bar Association
What
regarding the
bar association?
my lord, the NCLT Advocates Bar Association regarding the shifting of, my lord, the tribunal to, my lord, a distance of 24 kilometers from the High Court. My lord, that will, my lord, make it almost impossible for all advocates to, my lord, attend the NCLT.
So the NCLT Bar Advocates Bar Association is are the lawyers of this court.
Yes, largely.
Yes.
Very largely. My lord, there are also, my lord, practicing chartered accountants and company secretaries, but, my lord, the advocate members are, my lord, largely practitioners.
No, what is the urgency?
No, my lord, there is, my lord, urgency is that, my lord, ultimately, my lord, they are proceeding with the construction, my lord, money is being spent on, my lord, the new infrastructure. And,
Where
my
is
lord,
where is it shifting to?
it is, my lord, shifting to Rajarhat, but, my lord, it's not, perhaps not correct to say Raja is 24
And if the High Court
kilometers.
shifts to Rajarhat in the near future, then
My lord, I don't
then
see,
you will ask for the NCLT to come back to the original position. What will you?
no,
what
my
will
lord,
you
then we'll be happy to, my lord, go there, lock, stock and barrel. My lord, the difficulty is, my lord, High Court, my lord, here, and NCLT, my lord, 24 kilometers away. I don't think, my lord, it will be practical. My lord, access to justice system is what we are really, my lord, ultimately assailing.
Very well. 8th notice to the other side, please.
I'm grateful.
My lord. Yes.
my lord, with regard to, my lord, the
Hurry up,
writ
please.
petition, my lord, it was filed, my lord, the 2022, my lord, the private respondent is encroaching the land of the PWD, my lord.
Last cause of action.
My lord,
Last cause of action.
last, my lord, we came to know that it was going to sell.
Yes.
To
Come
other
back with
parties, well-
back with facts. Yes.
My lord, may I be permitted to mention a WPA writ petition number 5450 of 2023 for inclusion in the list, my lord. We have filed an application under section 14 of the SURFACE Act for before the
Secured creditor.
yes, my lord.
Application pending since.
Application is pending since 24th of January 2017 before the Larne District Magistrate Purbo Mednipur, my lord.
Very well. When did you file the writ petition?
My lord, on 13th March 2023.
No urgency. 11th May. Yes. Notice to
In
the
this
other
matter,
side,
my lord,
please.
I am for the respondent ECL, my lord. In this, my lord, there, my lord, is stay. There is a stay up for banning of business, my lord, passed by your lordship, my lord. Against that, but I filed review application, and there is also a stay, my lord, that we cannot issue a work order to the other side, my lord, in term of an undertaking given by me, my lord. But this matter, my lord, your lordship heard, my lord, on 10th April 2018, my lord, 2023, my lord. When, my lord, we said, my lord, that we will again give the petitioner a chance to appear for banning of business, and your lordship director.
Who is leading you in the matter?
Mr. Jishnu Chaudhary, my lord. And my lord,
Yes. What is it that you want?
urgency is this, my lord, we are losing my lord, every day, my lord, 80 lakhs, my lord.
Yes,
But,
11th May. Notice to the other side. Yes.
Your lordship, may I be permitted to mention one matter in the contempt application number 119 of 2023 arising out of an order dated 18/11/2022, wherein your lordship directed the responding authorities to disburse the amount due to the petitioners. But till now, the amount does not be disbursed to the petitioner.
When did you file the petition?
I filed the petition on 6th June of 2022, and after that the order has been
Never taken up.
no, it was taken up and an order has been passed. After that, contempt application has been filed on 24th January 2023. Arising of that order, till now the respondent order did not.
Very well. 12th notice to the other side. Yes.
Your lordship, may I be permitted to mention a matter WPA number 7258 of 2023, your lordship. Your lordship, I'm one of the tenant in a building where the respondent is carrying on the business of a restaurant without any fire emergency approval or anything, your lordship. And
Last cause of action.
your lordship, this is the first time, your lordship, I'm mentioning.
Yes. Come back with facts. Yes. You.
Your lordship, this is a matter wherein your lordship disposed of the application by passing an order on 31st of March 2023, directing my client to pay a sum of rupees 4 crores plus amount, your lordship.
Who is your client?
It's the Arunachal Pradesh Labor Department, your lordship.
Yes.
Your lordship, but that amount has already been paid and that was not brought before your lordship's knowledge, your lordship. And
What is the date of the order passed by the court?
31st March 2023, we didn't have a copy of the affidavits. We applied for the certified copy. We got the certified copy on 17th
Are you
April.
suffering an interim order?
Your lordship, there's a direction to pay by 4th April. So we are contemplating a contempt may be filed against us. As your lordship pleases, this matter could appear.
Very well. On 10th May, notice to the other
Obliged.
circuits.
There are two applications here.
May I have your lordship's kind leave jointly? We are praying before your lordship, my lord, that matter that assigned
Jointly, who is
with
the other
the
person?
respondent. My respondent is
Yes.
My lord, this is the remanded matter from the Honorable Supreme Court. It was appearing on last Wednesday under the
Assigned matter.
Yes, my
It will be taken up before the last Wednesday before the holidays, 17th.
17th.
17th May.
17th.
Notice,
May be
yes.
permitted to mention, my lord, for inclusion in the hearing. My lord, the petitioners participated in the bid. They paid the consideration amount to the respondent bank, has not been handed over the physical possession. That is the matter, my lord. Last occasion, the matter was appeared on 29th November 2021 before Honorable Justice Shobhashachi Bhattacharya. Lordship was pleased to release the matter for lack of determination as directed to approach the appropriate.
You're
bench.
appearing for the first time, you're mentioning
No,
for the first time?
First time, my lord. No, my lord, we have mentioned second time on 16th of April.
Very well. It will not be taken up this side of the vacation, but you can take your chance on 18th May.
18th
Yes.
My lord, with the lordship, I'm mentioning, my lord, one matter.
Can't hear you. My microphone, please.
My lord, on December 13, an order was passed by the district magistrate, and on, my lord, December 20.
December
immediately-
2013.
No. December 2022,
Yes.
13 December. My lord, they are trying to evict me from my business. Immediately, my lord, we filed
Who is they?
the district magistrate, my lord, in coalition with the, my lord, the PWD department.
Yes.
We have challenged this order, my lord. Now they have trying to evict me, and line has been disconnected day before yesterday. That is the urgency, lordship, my lord.
Line, what line?
Electricity line.
Yes, it's a pending matter.
Yes.
Very well. On
Listed motion.
first.
First.
May I have
First,
your lordship
extremely
leave to
grateful.
mention, my lord, on
I'm
Please
extremely
wait.
grateful.
Yes, Mr.
non-prosecution, my lord.
Yes.
24th, we received a summon under the provisions of the Competition Act 2005.
Summons by who?
Directing us, the Competition Commission of India,
Yes.
directing us to appear on 26th. Now, there is no order on record which is
26 July or
of
August?
this month, 26th of April.
Yes.
But we didn't appear because on 24th we filed the writ petition on receiving the summon on 21st. There is no order directing the issuance of summons or carriage of any proceeding. I'm apprehending initiation of warrant proceedings or not any order which will seriously affect my business. I filed it on 24th on receiving the summons on 21st.
Very well. On 2nd May,
Grateful
notice
to
to the
you.
other circuits. Yes.
May I get your lordship kind in just to
Mr. Paul, you have to wait for the second mentioning. Yes.
Non-prosecution, my lord, on matters.
Which year?
2022, my lord.
You have to watch the list. I can't tell you when the matter will come. Yes.
Respondent bank has invoked
Can't hear you. Yes.
Respondent bank has invoked a general lien matter under section 171 of the Indian Contract Act over an amount of 74 lakhs, which has been credited by the railway authorities in favor of the joint venture firm on the account of the joint venture firm.
I can't understand. Who are you? What is the cause of action?
Cause of action is that, my lord, the bank has invoked a general lien over an amount of 74 lakhs, which has been credited to the joint venture firm where my petitioner is a partner, my lord, and they have the amount has been withheld by the bank more than 2 months, my lord, without any, they have no any financial liabilities.
Last cause of action?
Last cause of action, my lord, I have filed this petition on.
Last cause of action is not filing of the writ petition. Facts.
Last, my lord, it has been, the fact is that they have
Come
no
back
any
with
financial
dates.
liabilities.
Come back with dates. Yes.
My lord, my lord's kind leave, may I be permitted to mention?
Microphone, please.
My lord's kind leave, may I be permitted to mention an application, my lord, for inclusion in the list, my lord. This is for
In a pending writ petition.
It is a pending writ petition, my lord.
Yes.
The application is for modification of my lord's order,
Dated?
whereby my lord, that order is dated 4th July 2022. Thereafter, my lord had directed it to be listed on a number of occasions. It could not be.
When did you
My lord,
file the application for modification?
My lord, that was filed, my lord.
Yes,
shortly,
come
my
back
lord.
on the next day. Yes.
Your lordship, the matter is running in the combined monthly list for the month of April. It's at item number 320. Your lordship, I am a jewelry shop owner. My shop has been illegally closed and I'm not being allowed to open it by the private respondent.
Give me some dates, please.
Your lordship, in the month of from the month of November 2022,
Yes.
I'm not being allowed to open my jewelry shop.
When did you file the writ petition?
In December 2022.
Very well. On 16th, notice to the other side, please. Yes.
My lord, may I permit to mention one matter, my lord? Petitioner is the owner of a excavator, my lord, but the respondent.
Owner of what?
Excavator, my lord. But
Yes.
the respondent authority is illegally withheld your petitioner's excavator, my lord.
Dates.
My lord, on 10th of February 2023, my lord. They are illegally withheld, my lord. I have filed the writ petition, my lord, but the
It's a bank.
No, my lord, it's not the bank. It's my lord, the
No,
assistant.
who has withheld?
My lord, the assistant commissioner of state tax, my lord. Assistant commissioner of state
When
tax.
did you file the writ petition?
My lord, on 3rd of April, my lord.
Yes, 10th May, notice to the other side. Yes.
Lordship, grateful lordship.
My lord, may I have my lord's leave with regard to my lord item number 220. My lord, this is my lord a writ petition which we have to file against my lord the registrar of companies. My lord, in view of a judgment passed by my lord, whereby my lord, I being the managing director and 50% shareholder, and there being an NCLT order of 241 in my favor, lordship had passed a judgment, my lord, that they cannot operate the bank accounts. Now that judgment has been upheld by the division bench also on 1st of March 2023. Now, my lord, what they have done now, my lord, is that they have filed, my lord,
They
forms.
as in? They
My lord,
as
the
in?
respondents have filed, the other, my lord, shareholders have filed, my lord, the forms before the ROC and has, my lord, struck my name off as a director. Now, my lord, the banks and all are again, my lord, not allowing me to operate or, my lord, send any notices to them.
Dates, please.
My lord, the order of my lord is, my lord, of 11th of November 2022, and the division bench order is of 1st of March 2020.
No. When did the bank do all these
My lord,
things?
this now, my lord. I filed the, my lord,
What is now?
my lord, last week they have sent us a notice, my lord, saying that the other banks will not, my lord, operate since the order is not on them, my lord.
11th May, notice to the other side.
Grateful, my lord.
May I have your lordship's kind leave to mention a pending writ petition being number 1305 of 2023. Your lordship was pleased to pass an order dated 17 February 2023 directing the private respondents to not alienate the property in question, being the subject matter of this writ petition. However, they are trying to alienate the property at present in violation of such order.
Give me some dates, please. Every time I have to ask you the same thing.
The order was passed by your lordship on the
No,
17th.
come back with the dates of the cause of action. Yes.
I want to mention one
cause-
matter.
No,
This
come back.
This matter was rejected to be listed by your lordships on 22nd February 2023. Accordingly, it has been listed, but it is getting degraded day by day.
Degraded.
Degraded. Now,
As in devalued.
Today it is listed as item number 213. It is against the Airport Authority of India. They have
urgency, please.
They have kept around 50 lakhs rupees.
Who is they?
Against the Airport Authority of India Limited.
Yes.
But they are not disbursing my money due to some reasons or others. So let me say it will hardly take 5 to 10 minutes.
Come back after the holidays. Very well. The week before the holidays. Yes.
My lord, may I mention item number
Yes.
64 of your lordship's list? My lord, this was with regard to video recording of the proceedings before the medical council. Lordship,
Yes.
If
I
it
remember
was
that.
last heard on 20th March, my lord, I'm praying for upgradation any
Yes,
day
yes.
as per your lordships.
Yes. Is it? It's a new motion.
It's a new motion.
11th te kore dao to 11th. Notice
My
to the
lord,
other side.
may I be permitted to mention this matter? My lord, the respondent authority, that is the irrigation department, made fencing in the front portion of the petitioner's plot of land, thereby restraining his egress and ingress totally. Now, my lord, on 16th September 2020, 2nd September 2022, the petitioner made a representation before the respondent authority for removal of the fencing and for allowance of the egress and ingress. And my lord, by order dated 16th September.
What is it that you want now? You're not arguing the matter now.
My lord,
What is it that you want?
I am praying for inclusion of the matter in
Inclusion.
Inclusion, my lord.
Not filed yet.
No, my lord, the matter is filed, but not running in the list, my lord.
It will be in the monthly list of June, not before that. Yes, monthly list
May I
of
have your
June.
lordship's kind leave to mention a matter for
Grateful,
lordship.
ma'am.
This is seeking directions upon a respondent bank for return of an amount that was paid to a certain recipient erroneously.
Yes,
The
come
lordship-
back with facts. Don't make vague
Permitted mention for inclusion in the list, my lord.
urgency.
Urgency, my lord, I am the freedom fighter. Man, 13 months issued the notice, stop my freedom fighter pension, my lord.
You don't know the year?
Yes, my 23.
Yes. The court will assume the year, or you will give the court the year.
And issue the notice not to stop my freedom by the
Not to stop your.
stop the freedom by the pension.
What is the date of the notice?
My lord, notice 13th February 2023, my lord.
You are saying 13 March.
No, my
When did you file the writ petition?
my lord, filed 21st March 2023.
Very well. 8 তারিখে করে দাও তো উপরে তুলো. Yes.
No, item number 151 of the today, this matter is some extreme urgent because of this fact. On 16th March 2023, I was given approval for the post of the my lord Muslim marriage register in case of Arambagh police station. But still now I am not.
2003 তা দিও না. 2003 না 2023? Yes.
No, on 16th March 2023, I was given approval for the appointment to the post of the Muslim marriage register inspector of Arambagh police station.
Yes, yes. What is the urgency?
Urgency, I'm not still not getting appointment later. Though approval has been granted.
Very well. So approval granted when? When did you say?
16th March.
When did you file the writ petition?
28th March.
Yes, on 11th May. Notice the other side.
My lord, may I pray for your lordship's
11th
kind
May.
leave to mention a contempt application for inclusion in your lordship list. My lord, disobedience of your lordship's order dated 23rd November 2022. Your lordship had directed the respondent authorities, my lord, to
12th May. Notice the other side.
My lord, may I have my lord's leave to mention an application for inclusion in the list, my lord. This is with regard to enforcement of my lord's order passed in a writ petition on 17th of July 2022. My lord had directed banks to make payment.
Can't understand what you're saying.
I am praying for inclusion in the list of an application.
Contempt.
No, my lord, for enforcement of my lord's order. My lord had passed an order on 17th of July 2022, directing the banks to refund my entire amount, which had paid in terms of an auction purchase. My lord, the bank, that period had expired on 21st of November 2022. The bank has still not repaid the amount. This is my application for enforcement of my lord's order. My lord, this
Just 2 weeks left before holidays. It will not be taken up. I'm telling you. Yes, on 17th. Yes.
My lord, item number 799.
Can't, please, microphone.
My lord, item number 799 of April's monthly list, my lord. My lord, the petitioner is the widow of the public prosecutor of Bardhaman district and session judge, my lord. My lord, the remuneration for the work which the husbands of the petitioner was discharged, my lord, is due for the year 2017 and for the year 2017 to 18, my lord. My lord, last representation was made by the petitioner on 10th August 2022, my lord. My lord,
When did you file the writ petition?
My lord, November 2022.
Yes, 11th May. Notice the other side, please. Yes.
Item number 409 of the combined list, my lord. My lord, the private respondent, my lord, on the strength of a my lord, school final certificate, my
Come
lord.
back on the next day.
My
Yes.
lord, my lord,
What is the urgency?
my lord, urgency is that my lord, the private respondent is my lord recording my properties in his name, my lord.
Come back on the next day. There's no urgency. Yes.
My lord,
Lordship,
Yes, yes.
bank authority illegally and unconstitutionally.
Yes, next day.
released the murder.
Next day. Yes.
My lord, may I be permitted to mention one matter? It is appearing as item number 96 in the monthly list of April. My lord, this matter relates to the criminal misappropriation of funds. One Shobita Vishwadev Sharma of Tata AIA.
Next day. Yes.
May I be permitted to mention one listed motion for inclusion? It was filed on 20th June 2022.
Next day. Yes.
Lordship, the
Yes.
urgency is.
No, next day. Next day I'm mentioning. Yes.
Original side mentioning.
Lordship, may I be permitted to mention on
Mr.
appearance?
Paul, I don't allow second mentioning. What is it that you want?
Lordship, urgency is that Lordship technical bit has opened on 14th, Lordship. I have made, my technical bit has been rejected. I have made one application, but they have not considered. I have
Not
filed it.
for the second week of May, Mr. Paul.
Lordship, next week, they may.
Next week, 4th will be a very short, very well 4th. Yes.
May I be
Yes.
permitted to mention
It
item
will not be
number
taken up. It will be a very short list. Yes.
Item number 79 for upgradation, your lordship, the urgency is that the private respondent was removed from the board of directors of the petitioner way back on
When?
3rd of February 2022. Lordship, there
Come back on Thursday. Yes.
May I be permitted to mention, my lord, this matter I mentioned, my lord, earlier.
Thursday, original side.
My lord, I had
side.
mentioned.
No,
my lord, only
original
thing is my
side.
lordship
Original
directed
side mentioning.
to appear in the 4th week of
No,
April.
original side mentioning. Come back on the next day.
It is in.
Original side mentioning.
Appellate side.
Yes, call on the list, please.
Appellate side daily list item number 1. I am for the petition, but I am praying for correction of the presentation form. But the matter relating to all, my lord. So, my lord, it has been mentioned as group 9, but it will be group 1.
Yes, learned counsel appearing for the petitioner seeks leave to correct the presentation form as the matter relates to group
One.
Group 1. Stop, leave is granted and the matter is released from my list for want of determination.
My-
Next,
Maybe place before the appropriate bench.
leave to approach the appropriate bench.
My
Next,
lord, give it to us.
yes, what are the decisions you wanted to cite?
Item number 2.
You have 2 minutes, please. Just hand up the decisions, please.
Lord, one decision is that.
I can't hear you. Microphone,
Lord,
please.
one decision is that the Harshad Govardhan Sondagar case, my lord, and this was further.
Are you aware of all the Supreme Court decisions right from the Tondon and Phoenix, ARC, all of that?
Sajdev, Kanayalal, Sajdev,
Then
etc.
is this decision before that or after that?
Yeah, after that.
After that?
First, yes. First one is the decision of the Supreme Court in 2014, volume 6, SCC.
Why are you
1.
saying after that? You don't know that
I have seen.
Taunton and Phoenix ARC, that's 21, 22. Why are you saying after that?
Satyavati Tandon's case is long back. Long back. It was
Very well. Phoenix ARC.
Malas Phoenix has been dealt with. Our last position is that so far the deal.
Show me any decision
Yes,
after Phoenix,
yes,
please.
yes, yes.
Only decisions after
Yes,
Phoenix.
my lord. Paragraph 22 of this decision, my lord, will help.
Only decisions after Phoenix.
Yes, yes.
All right.
Next decision will be after Phoenix. Phoenix, it is Phoenix. And it
This is 2015.
Yes. No.
Show me decisions after Phoenix.
My lord, this is the decision, my lord. Kindly come to this decision, my lord. This is what your lordship is trying to say.
After Phoenix.
Yes, after Phoenix.
I can't hear you. Please learn
After
to use
Phoenix,
the
my lord.
microphone.
First one is that this is passed in January 2022. This is regarding.
This is Phoenix. This is against you.
Yes. Against me.
Yes.
But absolutely right. This decision says that any type of dispute between the borrower and the bank, it will be referred to the DRT. Nobody, no other forum. But so far, after that, a decision has been passed. That is in the year 2022, my lord. Long after this decision, my lord, in December.
Phoenix is 2022.
It is also after that.
What do you mean long after?
After on September 26, 2022, their decision came on the aspect that why DM order can be challenged before the High Court. Paragraph, my lord, 17 will give a good answer to that. That I wanted, paragraph 17.
Have you given your learned friend a copy?
My lord, I have a counter judgment to all this judgment which was passed on just on 17th of April 2023, which are.
Give the opportunity. Let me submit.
No, I will only consider this case. No other decisions.
No, Phoenix case, after Phoenix case, this judgment has been.
Very well. Paragraph?
Paragraph, my lord, 17. Paragraph 17. Page
17?
Page 17.
Which paragraph?
Page 17, my lord. Kindly come from page number 16. Kindly come from page number 16. What happens, my lord, of this judgment? This is the last paragraph. Thus, the power of exercisable by this CMM-DM under section 14 of the SURFACE Act are ministerial steps, and section 14 does not involve any adjudicatory process or points raised by the borrower against the secured creditor taking possession of the secured asset. In that view, the matter, once all requirement under section 14 of the SURFACE are completely satisfied and by the secured creditor, it is the duty cast upon this CMM or DM to assist the secured creditor in obtaining the possession, as well as the document related to the secured asset, even with the help of any officer subordinate to him, or with the help of an advance advocate appointed as the advocate commissioner. Now, my lord, at that stage, the CMM oblique DM is not required to adjudicate the dispute between the borrower and the secured creditor and between any other third party and the secured creditor with respect to the secured assets. Now, very important area, and the aggrieved party to be delegated to raise objection to the proceeding under section.
So this is against you. Why are you pointing
No,
this
my
out?
lord, kindly see, at the stage, I would respectfully submit, at the stage, CMM is not required to adjudicate. And come, not required to adjudicate, and the aggrieved party to the delegated to the raise any objection in the, so it should not be delegated.
It has to go, the borrower has to go before the DRT under section 7. This is against
No,
you.
my lord, this is not saying
Very
like
well,
that.
very well. You challenge my,
Kindly-
you challenge my order.
No, well, kindly.
Don't waste the court's time. Any other decision? Any other decision? Any other decision?
Court এখনো পর্যন্ত আমরা শুনছি, হ্যাঁ, yes, my lord. So this decision, my lord, what happened? Bombay High Court passed an order, my lord, in a writ petition, my lord. Supreme Court set aside this.
Please, Mr. Banerjee, any other decisions? Don't waste the court's time. Any other decision you have? I will consider it and pass the order. Any other decision?
Only thing, my lord, this is the interpretation I am trying to.
No, your interpretation is absolutely wrong.
Thank
Yes,
you.
yes.
This was passed on 17th of April, my lord. It is dealing with all the cases.
I'm
my lord.
telling you,
ARC
Phoenix ARC is against you. You're going on
Another
arguing.
judgment, my lord. No other judgment. It
Very
is
well.
based on,
Yes.
my lord. It is based on Harshad Govardhan case.
No,
This
I
case-
will not look at that. Yes.
My lord, this is relied upon the Harshad Govardhan
No,
case.
no, no.
Acha, let me read
Very
once.
well, no.
Let
Don't
me read
wait.
once, my lord.
Mr. Banerjee, don't irritate the court. This is not the right court to irritate, please. I have kept the matter to be mentioned only because you said that you have cases. It's a decided point. Don't argue and irritate the court.
My lord, kindly.
Do it with others, not this court.
Question of my lord position.
Yes, yes.
May I read
Which
all
paragraph?
answer,
Which paragraph?
My lord, I'll straight away come to paragraph number 18, your lordship, which is at the last page number 16, my lord. It is saying that while doing so, we are conscious of the fact that the powers conferred under Article 226 of the Constitution are otherwise but are required to be exercised in only
Paragraph?
extraordinary circumstances in matter.
Paragraph?
Paragraph 18, your lordship.
This is
And-
not numbered. Which there are
Lordship-
no paragraphs here.
Lordship, paragraph number
Paragraph 18 at page.
Last page, your lordship, page number 16. My lord, this is completely dealing with all these points, and my lord, all the other judgments have been taken into consideration, starting from ARC, Phoenix, and everything, your lordship.
My lord, once more, my lord.
No.
One paragraph, my lord. Kindly, my lord, with humble request, one paragraph, my lord.
Which page?
My lord, kindly, that page, my lord. Page
That
number-
decision is against you, Mr.
My lord,
Banerjee.
kindly once, my lord, for page number 17. I will not further make any comment. My lord, my interpretation is that the DM order was challenged before the Bombay High Court in a writ jurisdiction. Bombay High Court set aside the order of the DM. They went to the Supreme Court, and Supreme Court said that the High Court upheld the order of the Bombay High Court. It is the fact of the case. My lord, kindly see the last portion. I could not read that point of time.
No, not
Page number
required.
17.
I
Page
have
number-
read it.
Page
I have
number
read it.
70, my lord. Kindly one line, my lord.
No, no.
I will not read
No,
any
no,
more
no,
line.
no, no,
Kindly, my
no,
lord.
no further. Yes.
One line, my lord. One line.
The matter was heard yesterday when learned counsel appearing for the parties placed the facts in the case. Stop. Since counsel appearing for the petitioner expressed a grievance that the decision sought to be relied upon was not considered by the court, the matter is kept, the matter is listed today. The court decided to list the matter today only to give counsel an opportunity to place the decision. Stop. Next. কালকে যেটা ডিকটেশন দিয়েছি কোর্টে সেটা থাকবে তারপরে কন্টিনিউয়েশন এই আফটার এখানটা the petitioners the decision sought to be relied upon by counsel, namely the unreported decision sought to be relied upon by counsel, namely Balkrishna Rama Tarle dead versus Phoenix ARC, is decidedly against the case of the petitioner. Stop. The other decision,
That is Harshad Govardhan case, my lord. That is reported in 2014. volume 6.
the other decision being South Indian Bank versus Naveen Matthew Philip of 17th. Are you relying on this or who is relying?
I am relying upon this,
Very
your
well.
lordship.
No point. Just
is decidedly against the petitioner. Stop. In that case, the Supreme Court held that although the district magistrate is not called upon to adjudicate the disputes between the borrower and the secured creditor under Section 14 of the SARFAESI Act, the aggrieved party is there. The aggrieved party is, however, to be relegated to the Debts Recovery Tribunal under Section 17 of the SARFAESI Act. Stop. A more recent decision delivered by the Supreme Court, pronounced by the Supreme Court on 17th April 2023 in South Indian Bank versus Naveen Matthew Philip, deals with all the precedents, PRECEDENTS, precedents in the matter, and holds that the power conferred under Article 226 of the Constitution is to be exercised only in extraordinary circumstances in matters extraordinary circumstances in matters pertaining to a statute, in extraordinary circumstances, and not in matters which involve a specific statute which provides for a redress and a specific mechanism to the aggrieved party.
More
Stop.
relevant paragraph, paragraph number 17.
Next, WPA 6365 of 2023 is accordingly dismissed without any order as to costs. Needless to say, the petitioner will have the liberty of approaching the statutory forum available to the petitioner. Stop.
Kindly refer to the paragraph.
Call on the next matter, please.
Your Lordship, kindly mention the paragraph.
Yes, call on the next matter, please.
I'm grateful, Your Lordship.
Grateful, Your Lordship.
Item number 3.
I appear on behalf of the petitioner. Yesterday, my lord, by the intervention of my lords, the matter was taken up before the Debts Recovery Tribunal. Yesterday, the matter was heard, and a further date has been fixed on 6th of June 2023. Your lordship may dispose of the matter because
Very well.
The respondent bank.
Learned counsel appearing for the petitioner submits that the concerned application was taken up by the DRT yesterday and has now been fixed for further consideration in June 2023. Stop. Counsel submits that the writ petition may be disposed of on that basis. Stop. Next, WPA 9617 of 2023 is disposed of as not raised, disposed of in terms of the above.
only one thing, the main application has been fixed on 6th of June 2023. Main
6 June.
Yes.
Next.
I'm grateful.
Item number 4.
My lord. Now, since your lordship has accepted, they have given the judgment. They were since they've given
How
the
many
judgments,
judgments, Mr. Mitra?
they relied upon.
How many?
They've given many, but then I will not distinguish all. I will rely upon some of their judgments on point.
Many must be the judgments only referred to in the note.
The petitioners have submitted several judgments referred to in their notes only.
Very well.
Of the judgments which they've referred to in their notes on the question of locus standi, there is a judgment of the division bench of our High
Just 1 minute. Mr. Mitra, have you given a compilation of judgments?
told me, Lord. A compilation with the index has been submitted. DH
Copy দাও।
copy দেয়নি?
দেখাতে সুবিধা হবে।
এটাই তো? Yes, yeah.
Copy দাও, দেখাতে
Copy to
সুবিধা
them,
হবে।
copy now.
Yes.
Copy.
We have not got the compilation, but the judgment referred there, Shubir.
Just 1 minute, please.
No, copy.
Which one are you referring to?
Serial number 6, page 112.
Yes, yes. That is on the point of?
On locus standi after participation, whether you can participate or not.
Yes.
Page 112, that is serial number 6.
Yes.
Shubir Ghosh.
Yes.
Paragraph 5. It is possible that a prospective bidder finds the term of the
No,
tender.
you're relying on paragraph 5 or they have relied on paragraph 11. You're relying on paragraph 5.
They have relied on paragraph 4 and 5, and I am also relying on paragraph 5. They have relied on paragraphs 4 and 5, page 4 of their note.
Yes, yes.
Paragraph 11.
Yes.
Paragraph 5, it is
Yes.
It is possible that a prospective bidder finds the terms of the tender documents to be unfair or illegal and challenges the same. But such challenge has to be before the time to put in the bids is closed. I am on that. At any rate, if a bid is made and the bid is thrown out on an illegal or unfair ground contained in the tender documents, even then a challenge can be fashioned. So before the bids are closed, here the bids were closed on 4th of April. They submitted their 4th or 5th, they submitted their bids on 4th April. And they filed a petition well after a month after that or thereafter. I had cited 3 more judgments. I'm relying about 1 more judgment, which my lord was kind enough to refer to. That is Justice Surya Kant's judgment, which also I in humble sub.
Paragraph 17 and 18.
Surya Kant, copy now.
I'm not very sure. Does it help you? I was looking it
Yes,
up
but
last evening.
That possibly. What I will show this also. You kindly see paragraph 19 first. Paragraph 19, page 26. Page 26, the
Yes.
2019-20 SCC,
Yes.
page 17.
Yes.
The appellant has thus rightly not challenged the selection procedure, but has narrowed her claim to only against the respondent's interpretation of work experience as part of their merit determination. And now, Lordship, kindly see this in conjunction with paragraphs 15, 16, and 17. 16. It is well settled that the principle of estoppel prevents a candidate from challenging the selection process after having failed in it, as reiterated by this court in plethora of judgments. Now, Lordship, kindly comes to the next page. The underlying objective of this principle is to prevent candidates from trying another shot at consideration and to avoid an impasse wherein every disgruntled candidate having failed the selection challenges in hope. Now, para 17 is the exception to it. However, we must differentiate from this principle insofar as the candidate, by agreeing to participate in the selection process, only accepts the prescribed procedure and not the illegality in it. In a situation where a candidate alleges misconstruction of statutory rules and discriminating consequences arising therefrom, the same cannot be condoned merely because the candidate has partaken in it. The constitutional scheme is sacrosanct, and its violation in any manner is impermissible. In fact, a candidate may not have locus standi to assail the incurable illegality or derogation of provisions of the Constitution unless she participates in the selection process. The question of permissibility of giving weightage for work experience in government hospitals is also not the bone of contention in this case. Medicine being an applied science cannot be mastered by mere academic knowledge, so and so and so. Now, Lordship sees the appellant has thus rightly not challenged the selection procedure, but narrowed her claim to only against the respondent's interpretation of the work experience as part of merit determination. Since interpretation of a statute or rule is the exclusive domain of courts, and given the scope of judicial review in delineating such criteria, the appellant's challenge cannot be turned down at the threshold. However, we are not commenting specifically on the merits of the appellant's case. The determination is alien to the outcome. So, but the interpretation, if from JC's side that interpreted any tender condition wrongly, that could have been challenged. Of course, then there are judgments which says they are the last authority in interpreting their own documents. But then if it's
So you're saying that the petitioners in this case, they are not challenging interpretation of any of the terms of the tender?
They are simplicity challenging the NIT procedure having participated. Simplicity is challenging the selection procedure. And Lordship kindly sees their amendment, their can application, their can. Lordship, their can one, the prayers made, not the way it's been implemented.
Yes.
Page 121 of can 1.
Page 121.
This is the amended.
Yes, yes.
Prayer is declaration that the eligibility criteria of the inspection agency has determined and fixed by the notification dated 23rd August. This is only a request for proposal are valid. So the criteria is valid. And written the nature of writ of mandamus, we commanding and so acting on the basis of the eligibility criteria as fixed in December 19. On
yes.
Simpliciter. And apropos 19, I also want to show, my lord, apart from what I have said in my note, because when we were discussing yesterday, I find this a very relevant point is in the supplementary affidavit filed by the supplementary affidavit filed by them on 7th February 2023 by the writ petitioner. This is Manoranjan Jena's supplementary affidavit. Page 14.
I am instructed this affidavit has not been filed by us. File করেছে তো বলতে
Page 14.
We are not relying on this, but when have you said so?
An admission can't be withdrawn.
Mr. Mitro, Mr. Mitro is relying on it.
No, so I'm not properly instructed. I'm not properly.
No, you, but Mr. Mitro wants to rely on your supplementary affidavit.
That's what I.
My lord, since in the supplementary affidavit, the stand we had taken, subsequently we've amended the writ petition because the order came and we amended the writ petition itself, which is why we did not file the supplementary and instead filed the application for amendment.
Well, anyway, this is the order of court in the earlier proceeding, page 14. This I could have handed up anyway.
Page 14. Page 14 is a pleading. Eta konta dile?
This is the order passed in Manthar order.
I think you placed it yesterday, but there's somewhere else.
Yes, this is where they had, in fact, the 2019 NIT. It is also in the can. My junior tells me so.
Yes, yes.
Then I. Yes. Lordship, page 23. Page 23 of the can one.
Yes.
Now, 2019 eligibility criteria they are challenging today, but 2019 NIT was cancelled, was withdrawn, and they wanted that tender to be kept alive. Lordship, can you see the first paragraph? The petitioners are aggrieved by the cancellation of the notice inviting tender dated 31st of December 19 issued by the Office of the Joint Commissioner for Empanelment of Agencies. And they wanted this tender to be alive, and this is dismissed.
This order they have challenged in a memo.
And this was now, and their appeal they filed from this, which is kept pending. So they want that to be kept alive.
And you were given the liberty to float a fresh tender.
And this is 22 tenders floated apropos that. And now they are saying revive the 2019 eligibility criteria is not good. They wanted that to be this is approbate, reprobate at the highest. And now, my lord, my next point here is that from my compilation, from our compilation of judgments.
Yes.
Yes, Lordship. Prestige Lights case, page 33.
Prestige Lights case.
Actually, compilation that is in my compilation, serial number
at 31.
Yes,
31
at
at
page
33.
31.
Yes.
Page 31, paragraphs 33 to 36. Since they got that order by not bringing
Paragraph
33 to 36. Paragraph 34 is the Russian princess case, R versus Kensington Income Tax Commissioners. Page 43, running page 43, Russian princess, then paragraph 35. It is well settled that a prerogative remedy is not a matter of course in exercising extraordinary power. Therefore, writ court will indeed bear in mind the conduct of the party who is invoking such jurisdiction. If the applicant does not disclose full facts or suppress relevant facts, was otherwise guilty of misleading the court may dismiss an action without adjudicating the matter. The rule has been evolved in larger public interest to deter unscrupulous litigants from abusing the process of court by deceiving it. The very basis of the jurisdiction rests in disclosure of true, complete and correct facts. If the material facts are not candidly stated or are suppressed or are distorted, the very functioning of the courts would become impossible, and then so on and so forth. In this connection, I will rely upon their judgment. The judgment, serial number 7 in the other side's compilation, writ petitioner's compilation. Praxair, page 114.
Yes. Yes.
Now, Lordship kindly sees paragraph 7. This was also an attempt by the tendering authority to widen competition by relaxing the tender terms.
Yes.
Paragraph 8. After detailed, this is post opening of tender. After detailed discussions, SAIL modified the eligibility criteria, making it broad-based and more inclusive, and extended the last date for submission of the tender. As on the said date, only the 7th respondent's bid was the only one available. The relaxation of eligibility criteria validated the bid of the 7th respondent who was not eligible as per the original eligibility criteria. The petitioner and the said INOX continued to be eligible to participate. Instead of submitting any bid from their side, they continued to protest the relaxation of it. And Lordship will see how the court then treated this. Paragraph 32, page 121, paragraph 32. Attempted widening to make somebody eligible, 32 to 34, 40.
Yes.
Admittedly, after receiving complaints, paragraph 32, an independent external monitor of SAIL had reviewed the entire tendering process threadbare. The minutes of the meeting of IAM clearly vindicate the procedure adopted by SAIL. The changes in the eligibility criteria appear to be wholly and completely justified in facts of the case. The writ petitioner and the said INOX, who are already generating cyrogenic, cryogenic oxygen in various steel plants, and the DSP were only attempting to extract favorable terms for a period of nearly 9 months from SAIL. The last of the changes to the technical commercial conditions demanded the by the writ petitioner and the said INOX were admittedly wholly prejudicial to the employer of sale. The relaxation, 33, the relaxation terms only facilitated the entry of the seventh respondent into the fray. Writ petitioner already having a cryogenic oxygen plant at DSP itself and operating another plant at Basic could have still, with equal, if not with better credentials than the respondent, could have still participated. The petitioner, however, chose not even to submit any bid for a period of 1 year and to continue to demand terms favorable to them and to the detriment of sale. The relaxation of eligibility criteria and the entry of the seventh respondent could not have therefore in any way prejudiced the writ petitioner. Now, Lordship kindly comes to paragraphs 42 to 47.
Paragraph?
42 to 47. 42 to 47.
Yes.
The questions framed are answered as above. Having addressed the aforementioned questions, this court finds it necessary to look into the conduct of the writ petitioner in the entire tender allocation process and in filing the instant writ petitioner, which has caused inordinate delay in the process of the functions of an instrumentality of the state. It is surprising to note how sale has allowed itself to be held to ransom by the petitioner and the said INOX. This court's mind is not free from doubt that the petitioner and other bidders, being established players in the field of cryogenic oxygen production, were trying to get a stranglehold on sale and to blackmail it to submit to their terms to the detriment of the latter's interest. Admittedly, a notice inviting UI for the subject matter tender was issued in December 2020. The tender terms, particularly on technical specification, were substantially altered in course of negotiation. Petitioner and the said INOX. Writ petitioner and INOX, having realized that there are no players other than players, that there are more players other than themselves, may have resorted to demanding terms that border on extortion. The terms demanded were certainly were clearly detrimental to the interest of sale. The petitioner did not submit any bid whatsoever and has filed the incident nearly a month after granting our seventh extension of deadline. So and Lordship will see paragraph 47. So it is dismissed with 5 lakh rupee cost. Here, even though there was no interim order passed, and here they have stalled the tender process and just continued there. Otherwise, they are disqualified from September 16, from September 22, because they came and said 2 notifications have not been implemented. So in humble submission, widening of competition cannot be a eligibility, cannot be a ground on which a tender condition can be challenged. And here, my lord, for this purpose, I am relying upon the Wells oft-quoted judgment in G.J. Fernandez, which is also in my note. In G.J. Fernandez's case,
G.J. Fernandez is not part of your compilation?
It's part of my compilation. Serial number 7, page 57.
Yes.
I hope paragraph will be. Yeah. Paragraph 15 at running page 70.
Yes.
Thirdly, the conditions and stipulations in a tender notice like this have 2 types of consequences. The first is that the party issuing the tender has the right to punctiliously and rigidly enforce them. Thus, if a party does not strictly comply with the requirements of para 3, so it is open to the KAPC to decline to consider the party for the contract. If the party comes to court saying that KAPC should be stopped from doing so, the court will decline the relief. The second consequence indicated by this court in its earlier decision is not that the KAPC cannot deviate from these guidelines at all in any situation, but that any deviation, if made, should not result in arbitrariness or discrimination. It comes in for application where the non-conformity with or relaxation from the prescribed standards result in some substantial prejudice or injustice to any of the parties involved or to public interest in general. For example, in this case, the KPC made some changes in the time frame originally prescribed. These changes affected all intending applicants alike and were not objectionable. In the same way, changes or relaxations in other directions would be unobjectionable unless the benefit of these changes or relaxations were extended to some but denied to others. The fact that a document was belatedly entertained from one of the applicants will cause substantial prejudice to another party who wanted likewise an extension of time for filing a similar certificate or document but was declined the benefit. It may perhaps be said to cause prejudice also to a party which can show that it had refrained from applying for the tender only because it thought it would not be able to.
Sir, Mitra, don't place the whole paragraph, please.
So it is if it is to widen participation, Lordship, the last 10 lines, it cannot be immunity from competition. So even if subsequent tinkering of the tender process, the last 15 lines, but we are inclined to agree with the respondent's contention that while the rule in Ramanna's case will be readily applied by courts to a case where a person complains that a departure from the qualifications have kept him out of the race, injustice is less apparent where the attempt of the applicant before court is only to gain immunity from competition. Now, my lord, last time there were 5 empaneled, these agencies. Now, inspection agencies. Now, as per the affidavit of the Jute Commissioner, 60% was being done by SGS. What we have learned, 2 other agencies were operating. This time, there were 6 participants. 6 participants.
In the 2022 round.
3 have been disqualified because for whatever reasons, including their SGS.
Yes.
So, my lord, it has the other 2, I am told, who had 60% budget though. And the other 2 who were empaneled last time are qualified this time also. Now, Lordship, my last point is that, which I want to show, is that the writ petitioners were in fact ineligible to participate in this tender because of their blacklisting. Lordship, page 185 of the writ petition is the particular clause
Yes.
4, 2B Roman 1 and 2.
Yes.
Not stand declared ineligible, blacklisted, banned, debarred by the procuring agency, Officer Jute Commission or its ministry from process. And Roman 2, not be convicted, so blacklisted, banned by appropriate agencies of Government of India from participation in tender process of all its entities for whatever reasons given. Now, my lord, Lordship will find here that that in my affidavit in opposition, page 68, the affidavit in opposition of, in the back sheet of Shomdatta Bhattacharya, the affidavit of Shankhomoy Banerjee. Shankhomoy Banerjee.
Mr. Mitro, just to finish this point
just give
quickly,
the
please,
point.
because I will be rising a little early. That is fine.
They had been blacklisted by IIM Kashipur. That is page 68 of my opposition. That was on 23rd.
There's a IIM
Kashipur.
in Kashipur.
There is some other IIM. Yes, Indian Institute of Management Kashipur, which is a government agency. Oh, this is Uttarakhand. Uttarakhand, they have. On 23rd May 20.
Uttarakhand has a Kashipur also. Yes, very well.
Canada has a London, so
of course. Yes.
Well, 23rd May 2019, they had been blacklisted.
29th May 2019.
2019. Well, there was an interim abeyance.
So that was after they challenged the 2019 or before that?
2019.
Justice Mantha's order you placed.
Justice Mantha's order, I'll tell you, Lordship. Justice Mantha, 31st December 19, before 2019.
Before 2019.
before 2019 tender.
No, but if they were blacklisted, you're saying then they challenge that blacklisting.
Oh, 23rd December, yes, is post blacklisting, they participated in the tender.
And they challenged the 2019
Tender
NIT.
by saying that it should not be cancelled and withdrawn, but it should be taken to its logical conclusion. Because they are enjoying an interim stay. Section 17 stay they have got, which they have given, which they have disclosed in their CAN application. There was an interim stay by an arbitral tribunal passed on 12th of June 2020.
Stay of?
The blacklisting.
So as of the challenge before the coordinate bench, there was no blacklisting.
There was
The
a stay.
was there.
Even there was a stay.
Yes.
Now, what is the effect of a stay? Stay does not obliterate the blacklisting. For that, I have shown. After all, this is only an interim stay. Show me the page 16 from their CAN status account, status.
So have you taken any steps against that? Or
no, but they have since the stay now.
The blacklisting has gone.
Gone.
So, Mr. Mitra, how is this relevant?
The point is, on the day they submitted their tender against the 22 NIT, that's on 4th of April 2022, it was stayed. But stay does not obliterate. That is, for that I relied upon Sudarshan Chit's page 72, paragraph 16. Page 72, it starts, paragraphs. P. 19 Paragraph 16, page 77.
Yes.
Paragraph 16. Now, if the winding up order was merely held in abeyance, it was not operative for the time being, but it had not ceased to exist.
Yes.
The winding up proceedings are in fact pending.
No, but are you saying that their blacklisting was a relevant consideration for their disqualification?
Yes.
It was.
They were not eligible. And that is why, my lord, I am showing their CAN, in their CAN, the query, Lordship will see the CAN, their CAN 1. Lordship will see page, the first annexure, page 16. The query which came from the ministry. Lordship should kindly come to third query at page 17.
Query to who? To the petitioner?
To the writ petitioner by the Joint Commissioner's office.
Yes.
All these was, as I said, these were suppressed. Also, the competent authority has observed that Mrs. CNP, one of the SGS India vertical, as mentioned in your bid document, has submitted the declaration certificate and extra for SGS Limited. On the other hand, all other essential documents, example, audited balance sheet, is in the name of SGS. Accordingly, I am directed to request.
So you're saying that the declaration was made by somebody who had not been blacklisted?
That's why their query was that they were repeating these queries again and again. That's when they came to court and got the interim order. This query was made. Their response was page 18. I will not give you a response because the matter is sub judice.
Who is the CNP inspection?
One of their units, possibly.
Yes.
I do not know. Some vertical, yes, some vertical of this. Not, no, that's why not in their name. And that's what they repeat, since they say that their response was matter is sub judice, I will not give my reply. Page 18. So then on page 20, 2nd September 2022, they repeat this same query. Please answer. Or you will see page 2022.
Mr. What is wrong with that? If a matter is already before the court, that's the practice which everybody follows, not particular to the petitioner here. Everyone says it does the same thing.
There was no stay of tender process.
Yes.
They had not moved the application. So they can't hold the tendering authority at ransom and say that since my petition is pending, I will not answer your queries and you do not finalize the tender. They can't do that. So when the tendering authority asks them to give the particulars.
So you disqualified the petitioner during the pendency of the writ petition without getting the answers to the queries.
But the answers to queries were not coming because timelines were there.
Yes.
2nd September, once again, the query was sent. 5th September, they said 4 weeks time is, 5th September, they wrote that 4 weeks time is required.
Yes.
Then they could not disqualify because they came to court and got it stayed. They could not disqualify. The tender process again got stalled because they were stalling initially by saying that this is sub judice, so don't proceed with the tender. But when the tendering authority, it seems, that gave them an ultimatum, please give your clarification.
And you're saying that there is no causation between the pendency and the disqualification?
No.
No.
No connection whatsoever. Because while it was pending, so they got it stayed. So for 6 months, they could not, for 4 months, they could not be, tender couldn't be proceeded with. In the month of January, when my lord clarified it that you can proceed but don't finalize the tender, then only it seems that the Judicial Commissioner's office proceeded with the tender and they found, and they were disqualified.
Independent assessment.
Independent assessment. It's that's what it seems by a communication, since they were allowed to proceed. But even today, they are continuing to be the empaneled agency because they are the tender results can't be declared. So my point is, they are deliberately given the declaration certificate in somebody else's name, and then they stall the tender process till such time as they could. Then they came to court and got an order. And so Justice Mantha's judgment relied upon by them. Praxair comes into application in this case.
Very well. That is all, Mr. Mitra.
And also, Malad, I have relied upon the NG, just 2 judgments, Malad, on this point.
You said you don't like their judgments. Why do you want to rely on them?
Not that. No, not that, Worship. On this eligibility criteria, this 9006 for CHN, that on the date when you submit the tender, if you're not eligible, subsequently that disqualification, blacklisting may be set aside.
NG projects, paragraph 23.
No, not NG project. This is my note, 2006 for CHN, Doyamoi Mondol, paragraph 13 of my note.
Yes.
Last page, paragraph 13 of my note.
Which one in your compilation?
In the compilation, this is the serial number 9.
Number 9 in their
Serial number 9, paragraphs 14 and 30. There also it was subsequently while during the pendency.
Yes, paragraph.
Page 80.
No, I have got the decision. Paragraph.
Sorry. I'm looking at the other side compilation. Can you give me 1 minute? Paragraph 14 and 30.
14
and 30.
30. And this is on which point, Mr.
This is on the point that subsequently their blacklisting went away. But this will not make their tender eligible, because on the date when they submitted the tender, they were blacklisted.
Very good.
They were blacklisted. So that is paragraph 30. On the basis of materials and record, is clear that when the application by private respondent number 4 was made, she was not in possession of the scheduled caste certificate issued by a competent authority, which was the prime criteria. In the absence of the same, the said application by respondent is to be treated as invalid.
That is all. Mr. Mitra, I will read. Mr. Mitra, you will come back on the next day?
Yes. I have not got the notes of the Youth Commission as yet, notes of argument. Can we fix a date by tomorrow? Huh? The second note.
My lord, I will not trouble my lord. Our distinction of their judgments, which I'm giving us.
Yes.
2 of them I've done it, and the rest.
That's the second note I'll get from him. The Youth Commissioner's notes of argument, they said they will submit.
Mr. Mitra, even the court has not been benefited by the note.
By my note.
By the Youth Commissioner's note.
Youth Commissioner's note, we have not got. We have not filed. Have they filed?
Even the court has not got. That's what I'm telling you.
No, we have not got. Tomorrow, can we fix a date? If they want to give a note, let them say I will not give a note, all right.
Can leave,
Completely my fault, Lord.
That is all right. You can take your time.
Right today, after Mr. Mitra has finished his arguments, I'll put in some of my points as well. On Monday, before your lordship, and before
Friday, then. Saturday, আমি উইকেন্ডে পাবো তাহলে। আমি রিকোয়েস্টিং স্যাটারডে।
Saturday আপনাকে পাঠিয়ে দেবো।
তাহলেই হবে, হ্যাঁ।
Very well.
And Monday, my lord, before your lordship, lord.
And the matter is coming back on.
Let us see you. When do you want it, Mr. Mitra?
If we get it Monday, then Wednesday, Thursday? Thursday, Mila.
Thursday.
Means,
Why do you need so
before.
much time? Then they can give it to you on Tuesday.
Yeah? We থাকবে না? আচ্ছা, আচ্ছা, like Dipon Sarkar will be away on Tuesday. That is, we can carry on, but.
And the
Thursday,
the
requesting
extension,
for
the
Thursday.
stay is till when? You're not enjoying any interim order now.
Enjoying. Yeah.
Very well.
Yes.
Learned counsel appearing for the petitioner will conclude his submissions on, I'm keeping it on Wednesday because Thursday it will be a very short
I
list.
see, Wednesday.
On 3rd May, 2023.
Wednesday.
Stop.
Grateful to you. তাহলে তোমাকে সোমবার
শনিবার দিন দিও। Sorry.
Call on the next matter, please.
রেডিও কেমন করে?
Item number 5. Lord, I am appearing for the petition, Lord.
Microphone, please.
Lord, petitioner before your lordship is a partnership form and followed by a notice inviting tender issued on 27th of January 2014.
Are you enjoying an order?
No, my lord, there was no
No.
interim order.
Yes.
My lord, followed by the notice inviting tender on 27th of January 2014. My lord, petitioner participated in the said tender and having been qualified in the technical bid, he furnished the financial bid and the financial proposal has been accepted by the, my lord, the authorities, and letter of acceptance cum work order was issued on 28th of February 2014. My lord, kindly have a look at the, my lord, the letter, my lord, the acceptance cum work order appearing at page 17.
What is the relief, Mr. Dotto?
My lord, I am seeking for an amount arising out of the, my lord, the running account cum final bill, along with the, my lord, the,
43.23 lakhs.
yes, along with the, my lord, the interest.
43.23 plus interest.
Interest.
And this is on account of the work done by you?
Yes.
Admitted?
Yes, my lord.
Where is the admission? And the work was on account of what?
Only thing is this, my lord. Initially, my lord, by an order dated, 2 orders are there. When this matter has been taken up, your lordship, and by an order dated 13th of February 2023, your lordship was pleased to pass a direction to file a report in the form of an affidavit.
13th February.
Yes. My lord, they did not do so. Subsequently, time has been extended. And my lord, subsequently, they have filed a report in the form of an affidavit.
Yes.
And my lord, by an order dated, my lord, 12th of April 2023, my lord, your lordship was kind enough to, my lord, to give us time so that, my lord, we can file the extension. Our extension, my lord, the exception has already been taken. And my lord, that is, my lord, we are filing.
Yes.
The moot question is, initially the point which has been taken in there, my lord, the report in the form of an affidavit.
Yes.
That is based on the 2 documents. One document is the amount for the execution of the work has been sanctioned by the Union of India. One document has been given. So that is neither here nor there. That will not, my lord, neither help me or, my lord, there is no dispute at all.
So are they saying that they are not liable to pay?
Yes.
They are saying they are not liable
to pay. Why, my lord? Only, my lord, they have placed a reliance. The person concerned who has affirmed the affidavit, he did not have any personal knowledge. On the strength of the, my lord, the report of the Comptroller and Auditor General of India, my lord, they are trying to, my lord, they wriggle out their responsibility, saying that we cannot pay the same amount. Although, my lord, it is admitted fact that, my lord, the subject project has been issued by them. We have completed the same satisfactorily. Thereafter, 2 running account bill has been paid.
What is the project about?
Project is, my lord, the land development. undertaken by the Milord Goni Khan Chaudhary Institute of Technology. Because at the time of
the contractor.
yes, and at the time of the Milord, the execution of
What is land development?
land development means because there are undulations, some filling up of the lands and all those things, Milord. By filling earth and all those things. And Milord, this work has been executed. Only Milord, the strength of the report is this, only the report of the CAG. Milord, if I Milord the place.
Say CAG.
CAG. Milord, kindly take their report first.
No, so they are saying that the Union of India is responsible for payment.
No.
They are not saying that.
What they did, Milord, CAG advised, by giving an advice, they have the liability which has been accrued. They have taken into in their capital account.
Yes.
They have taken into their capital account. Milord, kindly only take, Milord, I will give you travel to your Lordship, Milord, only placing 2-3 documents first. Page 17 of my read petition. Read petition.
Yes. Mr. Dotto, how much time will you take on this?
Only 15 minutes.
No, I will not
Only
give you
10
that.
minutes.
No, because I will have to rise at 12:20. So I will not give you that 15 minutes. I will sit again at 2, but I will have to go somewhere to see somebody.
My lord. So, Milord, so
5 minutes.
Milord, kindly have a look at Milord page 18.
It's a easy case, an easy case. You're saying admission, they are saying no admission. Why?
No,
Because
they are not saying a no admission.
they are
It has
saying
been
Union of
categor-
India has given that work, whatever. So dispute that, that's all.
So, Milord, kindly have a look at the page 18. The Milord, this letter acceptance come work order has been, Milord, forwarded to all the authorities, including, Milord, the Under Secretary Government of India and the Director General of the Central Audit and Kolkata, West Bengal. It is appearing at page 18, Milord, serial number 1 and serial number 6. Then, Milord, kindly have a look at, Milord, page 24. Page 24. This is, Milord, a final certificate of completion where, Milord, it is evinced therefrom that, Milord, the satisfactorily the subject work has been completed, which has been categorically mentioned that today on such and such as a result of the inspection of
I remember these documents.
Yes.
It's marked.
Milord, thereafter, Milord, the 25. This is, Milord, the final bill raised, which has been demanded.
Yes.
Thereafter, Milord, the one document, there has been a delay in making payment, page 27 and 28, wherein, Milord, the professor, the then Professor, Milord, who is the in charge, wrote a letter asking them to, Milord, to look into the financial impasse to the JKCIT so that the payment could be made. The next document is very important, that is appearing at page 29. This is issued by the Under Secretary Government of India, addressed to the, Milord, the writ petitioner. Only, Milord, I will take your Lordship, Milord, to paragraph 4, page 29.
Yes.
Addressed to the Director, Milord, in view of the NIT Durgapur is requested to clear all pending bills and the which has been submitted by the OSD GKCIT immediately as the financial year of the such and such. Then, Milord, kindly straightway have a look at their, Milord, the exception, their report.
Yes. Just show me the documents, please. That's all.
Milord, the document appearing at page annexure A, this is pertaining to the sanction of the amount. That is nothing is relevant. Milord, kindly straightway come to the relevant portion of the annexure of the inspection report of the accounts and such and such.
Page?
Page 15.
Yes. Yes.
So, Milord, I will not place his entirety. Only the objection is this. There was a, Milord, few guideline that one, Milord, the authority or the agency has been deputed to take care of, supervise and inspection the, Milord, the entire activities. In the instant case, Milord, that activity has not been monitored or supervised that particular organization. It is their objection. Only, Milord, I will place reliance of a decision that the CAG report doesn't have any, Milord, evidentiary CAG report doesn't have any evidentiary value, and more particularly, Milord, only, Milord, court cannot grant any relief on the basis of the report of the Controller and Auditor General. It has been stated by the Honorable Supreme Court. Only, my lord, I am placing reliance. Hold on. 2013-7 is.
Reliance cannot be made in the matter of disbursing of payments, disbursement of payments.
No relief can be granted. This language has been written.
Or
that-
no relief, in your cases, no relief can be denied.
Yes. My lord, since it is their matter, my lord, therefore, my lord, respondent cannot seek any relief because they are placing reliance on the basis of the, my lord, the Controller and Auditor General's report. My lord, just this is reported in 2013-7. এটা কোথায় 11 দিচ্ছে তো আরেকটা দাও। 13 টা দাও। My lord, paragraph, my lord, 54 to 66. Only, my lord, I am placing-
Don't place the paragraph, just tell me the point, please. 54
Paragraph, my
to
lord.
54 to?
54 to 66.
Don't place it. What is the point?
The point is this only relevant portion, my lord, I will.
What is the point?
67, kindly have a look. 67. Internal page 24, Placitum B.
Yes.
The question that is germane for the consideration in this case is whether this court can grant relief by merely placing reliance on the CAG's report. And the CAG's report is always subject to the parliamentary debate. And it is possible that the Parliamentary Accounts Committee can accept the ministry's objection to the CAG's report or they reject the report of the CAG.
That is fine. What part are they relying on from the CAG's report?
My lord, in his entirety, they are relying
No,
on.
just show me the paragraph. To deny that payment to you, just show me that part.
No, that has been stated in the affidavit, my lord. That has been stated in the
Yes,
affidavit.
show me the paragraph, please.
Page 18, my lord, I have annexed the document itself.
Page 9, paragraph 3.
Page 18, which part are you relying on?
2.2. There's the irregular land filling of estimated cost of rupees 10.24 crores.
Page 18, 1 minute, please.
Page 18 of my report.
Yes, 2.2.
2.2.
Yes.
Irregular land filling at estimated cost of rupees 10.
And this is in relation to the particular to the petitioner.
No, entire, my lord, the subject project.
So wherever there has been land filling, you have made certain comments.
No, it's not our comment, my lord. But may I
No, the CAG has made
Yes,
comments.
yes,
That's what I'm telling you.
But for the first time in 2010, this institution was, my lord, created. Now we were placed under the mentorship.
So entire 2.2 you're relying on. And on what basis that the cost of 10.24 crores was held to be what?
But that was the sanction granted by the that was the sanction granted by the MHRD.
Yes.
With a rider that the entire thing needs to be audited by the CAG.
And what has the CAG said?
CAG says that these are the irregularities in this particular process. But this entire thing.
Irregularities in what?
Irregularities in my lord contract, irregularity in my lord completion, because this has to be done by NBC, National NBCC. Because above 330 lakhs, any agreement regarding this should be through a recognized institution, not to any private institution. And the 5 read petition has been filed before Lordship by 5 partnership firm. Interestingly, 1% is common in all the partnership firm. There was no proper advertisement. Those things happen because till
So you are appearing for the Union of India?
No, I'm appearing for this institution. Since 2017, this institution don't have its own setup like director. This institution was under the mentorship of NIT Durgapur, and the entire thing happened under their mentorship.
Very well, understood. Yes.
Kindly take, my lord, page 8, paragraph S of their report, my lord.
Yes.
Subsequently, during the my lord, the audit dated such and such, the CAG advised to treat the long pending liability as lapsed and credit those capital fund. So they never said that we are not entitled. They never said that the work has not been assigned to me. They never said that, my lord, the work has not been satisfactorily completed.
Very well. That's all.
One, my lord, I am placing reliance upon, my lord, section 65 of the Contract Act.
Contract Act.
Contract. I have marked it. I have marked it below. Only in everything. My case is better than this, my lord. Even in the void contract also, if somebody has taken advantage of the said work, in that event also I am entitled to get the, my lord, the fruits out of it.
Yes.
And only, my lord, I am placing other decision. That is
Mr. Dotto, just give me the paragraph numbers, please. Don't place so many decisions on the same point.
No, not the same point, my lord. This is a case, my lord, where in a contractual matters also, my lord, the writ petition lies and there is no difficulty. Although, my lord, your lordship, my lord, taken this point, but this is a current decision, my lord, taking all the point, my lord.
Yes, yes. Taking all the decisions. Yes.
2023 2 SCC page 703. Only paragraph, my lord, 81.1 to 81.15. Relevant
This
is
is the
80
MP power.
Yes.
Which paragraph?
81.6. And other decision is below 2 paragraphs. Surya Construction reported in Surya Construction. 2000 below the 19.
But MP power, those paragraphs deal with non-statutory contracts.
Yes, this is a non-statutory contract.
Yes.
Lordship is aware of.
Hurry up, hurry up.
Surya Construction. Oh, yes.
Surya Constructions has not been referred to in MP power.
No.
No.
No. Milord, paragraph 3 and 4, where Milord the ABL has been Milord the cited also. Paragraph 3 and 4, where Milord even the award of interest has been categorically mentioned.
Yes.
Milord,
Very
that's all,
well.
Milord.
That is all.
Thank you.
Yes. Just give me one page of your of the page reference numbers and the points. Okay, one page.
Yes.
Not more than that.
Only
Half a page probably. Yes.
only page 18.
What? No, no further. Put it in your half a page. Yes, learned counsel appearing for the parties have concluded their submissions. Stop. List this matter on 4th May 2023 for counsel to indicate their points. One page. Half a page. If you give it in half a page, then order will be in your favor. All right.
Great, madam.
Yes.
Item number 6.
And give a proper indentation. Don't give it in a way that I can't read. All right. Yes.
Item number 6 to 9.
Indentation is gap between lines.
Or 5 to 9, same.
Yes. Same order.
Great.
Yes. Same order.
7, 8, and 9.
Get it back. Are the counsel for the Jalpaiguri matters present in court?
Please, my lords.
No, but the petitioner is not here, Mr. Mukherjee.
I believe.
Yes, Mr. Bose, will you just wait for 1 minute? I will just dictate the order. I've done it last night. Just dictate. Yes, Jalpaiguri matter to Dakota.
Jalpaiguri matter.
Because so that one of you can go up in appeal. Otherwise, you won't get that time. Yes.
Jalpaiguri matter, item number 1.
Madam, I'm appealing for the petitioner led by Mr. HON'BLE.
Last order to the. Last order to the. Mr. Ray, you have told Mr. Ray to be here? Very well.
I have personally given the.
Yes, that is all right. I have, it's a 5-page order. I'm just reading the operative part. The primary grievance of the petitioners, to the extent of the petitioners being denied the right to vote and contest elections of the Siliguri Bar Association, however, stands on a different footing. in Supreme Court Bar Association, whatever, the Supreme Court held that the right to vote is neither a common law right or a fundamental right, but a statutory right prescribed by statute. It was further held that even if an advocate is a member of several associations, the right to form an association or be a member of an association does not necessarily include the right to vote at every such association, general body, or election meetings. The petitioners have chosen to be members of the DRT Siliguri Bar Association and hence cannot complain of being deprived of the right to vote or contest elections in the latter. The petitioners also cannot urge that deprivation of such right would carry a consequential right to invoke the powers of the court under Article 226 of the Constitution. The prayer for interim protection is therefore rejected. In any event, permitting the petitioners to participate in the elections would also amount to final relief without deciding the question of cessation of membership. And so no final relief, but with regard to the cessation, I'll just read that part. Yes, the cause of action brought before the court has an element of public interest. Any amendment which would have the result of making members of the respondent number 1 into non-members without due process affects democratic principles of governance. Advocates play a vital part in the delivery of the justice system, reference that case, and cannot be dealt with lightly or shown the door without following due process. The impugned decision concerning cessation of membership assumes a public character and also affects a large body of individuals who are now before the court. Hence, this court is of the view that the writ petition is maintainable. The recent full bench decision of the Supreme Court, whatever in Kaushal Kishore, answered the second question before the Supreme Court, whatever, just read the order. So I have held the writ petition to be maintainable, and I will decide your cessation of membership from the Siliguri Bar Association. But with regard to your right to vote, no interim order.
Lordship, much obliged.
Please, my lords.
I think your lordship can fix a date.
Sorry?
Your lordship can-
No, you can carry this up in appeal. What do you mean fix a date? Yes.
Not at all.
That's why I'm delivering it quickly.
Not at all.
There are directions for affidavit, my lord.
Yes, can you give that direction, my lord, and the date for taking up the matter?
Affidavit in opposition within 2 weeks, reply within a week thereafter. List this matter after 3 weeks. Is that all right? You're happy not to vote. What is this?
I told the particular, just one extra legal matter. I told the particular.
Just
member-
challenge my order, go to the division bench.
Should go because this, if I go, I have to be armed with a decision. I am not armed with a decision.
No, but you wanted the right to vote.
I told your lordships 2 things.
Very
First,
well.
the secession.
If you're happy with the
Second-
decision, how
second,
does it, yes.
Mr. Miller, action.
Very
of
well.
Miller not permitting me to vote. That I say, Miller, that is not a fundamental right. As
But Mr. Bhattacharya, unregistered association is like a club. So please explore that point. Yes,
I'm grateful, my lord.
yes, next.
Grateful, my lords.
Yes, call on the next matter, please.
Item number 10, MB mining.
My lord, this is my application, my lord. My lord, had fixed this matter, my lord, today only for filing of notes, my lord. We had concluded our submissions, my lord. We are only to file.
My lord, this is the matter where, my lord, two contesting bidders, the L2 builder is saying that L1, the selection process is still on, that they are not eligible. My lord, although after participation. My lord, MB is the.
Where have I said that you file your notes?
His lordship
on the
said
last topic,
one page note
One
to
page
all parties. We
indicate-
concluded, Mr. Kishore. Dutt-
Mr. Bose, please hurry up and tell me what this in one line, please.
My lord, here.
Because I am constantly thinking about that other matter where both of you are on the 2 different sides.
No,
Yes.
no, that is another. That is bullet point. Man, that is bullet point only.
Yes, yes.
This one is, my learned friend has filed, Mr. Kishore Datto, his client, has filed saying, both of us participated and L2, my lord, he was L1. Now don't give it to him because I have subsequently discovered that this chartered accountant, etc., does not fulfill eligibility criteria. I say the tendering authority is the best judge. and you cannot,
My lord.
Fernandez, etc.
After waiting
This
for
is not justiciable.
After
My lord,
waiting
may
for a
I-
month, he challenged that.
To
After waiting for a month from the Lord opening of technical bid, after he lost in the financial bid, he came and said that raising some technical issue that this
That's
is-
that point that he was waiting for the
Yes,
information.
yes, that it is matter.
my lord, may I indicate,
7,000.
my lord, may I
There
indicate
are
the
so
2
many
points
of
that-
these.
Yes, I will give you a chance.
Even in number 4, I found someone is same point. I mean, I just was hearing, my lord. My
Number
lord,
4?
mine is the only acceptable note because it is 1 page. Others, he has made 4 pages, 2
My
to
lord,
3
only because-
pages. My lord will see.
I don't have the time to see so much of notes.
No, my lord,
I-
1 page I have given, my lord.
my lord, our notes is just, my lord, we've set out the relevant clauses of the NIT. That is the only reason. which
My
is
note is
pages,
not 1.5 page.
And we've distinguished the
1.5
judgments, my lord. That is all, my lord.
And with Lord one.
My lord, may I indicate the
My lord,
2
my
points that-
note is more decorative. Your lordship will.
Yes.
Maybe not.
Lord, only one indulgence, Lord. If my Lord looks into the order dated 20th April, my name has been recorded. Lord, 12th April, my name has been recorded as the advocate for the petitioner, but it has to be respondent number 2. 12th April order. 20th April, it is fine. 12th April, Lord, it has gone, Lord, as the petitioner's lawyer.
Mr. Chokro, you for the private respondent?
Yes, I am for the respondent number 2, private respondent. 12th April order, I have been, Lord, named as the petitioner's lawyer at the top.
What is the problem? If there is a mistake in one order, after that it's been
There's no
corrected.
mistake, only this, Lord, I am just pointing out.
No.
Very.
I don't see any problem. Yes.
My lord, the 2 points that we've challenged, my lord. My lord, I am admittedly the L2 bidder declared on 13th March 2023, my lord. On that very same day, my lord, I make a representation to the tendering authority, my lord, that I have, my lord, discovered that the L1 bidder who's been declared, my lord, does not meet the financial criteria. My lord, as per the financial criteria under the NIT, my lord, it is required that the total average income needs to be 280 crores, and my lord, the total average income must be arrived at from on the basis of realizations, actual realization. My lord, that criteria he has not met, my lord. Respondent number 2, even during their submissions, my lord, no dispute as to their ineligibility in respect to financial criteria. That is our main contention, my lord. Apart from that, my lord, a particular certificate was supposed to be furnished with their bid documents. my
Mr.
lord.
Mukhopadhyay, I will see your note.
Lord.
Have no doubt about that.
My-
All right. I will see your note and decide the matter accordingly.
My
Much
Lord,
obliged.
we have all filed our notes. Grateful to you, Lord.
Much obliged.
Yes, but Mr. Mukhopadhyay, you have argued well. I must say that. Yes.
My lord, I was being led by Mr.
No,
Dotto,
no,
my
he
lord. I
never
did not
argued.
argue.
My lord,
Mr. Dotto, my lord, was.
Mr. Bose?
encouragement only. From the-
Yes. Yes.
I told him 4 pages is too much.
My lord, it's only because of particular
Mr.
points.
Mukhopadhyay, don't worry about what Mr. Bose is saying. You've done a good job. Yes, yes.
So he came to my house for some other matter. Actually, I mean, 4
Yes.
pages today.
Yes. Learned counsel appearing for the parties have indicated their respective points. List this matter on 8th May 2023 under the heading for judgment.
My lord, one indulgence, my lord. My lord, we have not obtained any interim order, my lord. My lord, let them stay their hands till the judgment. My lord,
No, I am indicating a date for judgment. I'm not keeping the matter in a limbo.
much obliged, my lord.
Yes, call on the next matter, please. Mr. Chakraborty, never do that, please. I'm very uncomfortable with those things. Yes. Yes.
Item number,
Yes.
item number 11,
Uh,
Anup Saxena.
Lordship, the respondents were to deal with the 2 judgments which we had cited in the
Yes.
last occasion. And Your Lordship, the interim order is expiring on 30th April, Your Lordship.
Very well. Yes.
My lord, I am for the respondent sure. Well, last occasion, my learned friend cited 2 judgments before your lordship. My lord, relating to the first decision, I humbly submit that the facts of this decision and the facts of the present case is not similar. That's why, my lord, that decision is not applicable. And relating to the, my lord, the second decision, I will not make any submission.
Just 1 minute, please. Which two decisions? You're not making any submission with what? I could not follow.
Relating to the second decision, my lord, cited by my learned friend.
What is the second decision?
Yogesh Agarwal, estate officers, and a bunch of cases.
Section 9 point, your lordship.
It relates to the, my lord, section 9.
Your lordship, my learned friend had argued that this writ petition is not maintainable as there is an alternate remedy. They could have preferred appeal under section 9.
Yes.
We have cited a judgment saying that order under section 5A. Section 9 does not provide for an appeal as far as section 5A is concerned, and a writ petition is maintainable. And for that purpose, we had relied on a judgment which said that as far as order under section 5A is concerned, it cannot be under section
Very
9.
well. So you're saying that section 5, section 4.1 and 5 is on a separate bracket, and 5A, 5A2 is on a separate bracket.
And
That
the
is what
order,
you're
yes,
saying.
and the order is under section 5A.
Very well.
And section 9 does not permit any
That
appeal
is the
as far as
Allahabad High
Yes,
Court. Yes. And the other points taken is also about the jurisdiction.
The other point, your lordship, is cited that the hearing was held in front of one person, your lordship, and the order has been passed by other person. Though the primary point is the notice was under section 4.1 and the order has been passed under section 5A, which is not in accordance with the act.
Very well. Yes, learned counsel appearing for the respondent railways has given his comments on the decision cited by the petitioner. Stop. Decision cited on behalf of the petitioner. Lists this matter on 10th May 2023 under the heading for judgment.
Your lordship, the interim order, in the meanwhile, the interim order.
The interim order is extended till 12th May 2020, till 15th May 2023.
I'm grateful.
Yes, I'm rising now. I will sit at 2.
Can the next matter kindly please stand over till tomorrow?
Item number 12.
May it please Lordship.
Microphone, please.
My lord, I'm pleased to take up this matter. Yesterday, if your lordship recalls, Mr.
Yes.
Jena had appeared on behalf of the Port Trust.
Yes.
This is a case in which there were 3 plots which were under lease, 1 under registered lease and 2 under unregistered leases which were awaiting registration.
Yes.
The Kolkata Port Trust authorities,
Yes,
my lord.
yes, I
Yes.
remember.
My lord, I'm pleased to record, my lord, in yesterday's order that it is undisputed that they have not taken steps under Section 4 of the Public Premises Eviction of Unauthorized Occupants Act, 1971. Side by side, it was my lord's desire, my lord, that we go back, my lord, and come back with instructions relating to some agreed amount of payment which can be made, my lord. My lord has not interlinked the granting
Yes,
of the
yes.
interim
What is
order.
it,
Well,
Mr.
two
Shah?
things. Well, Section 4 notice has not been given. That's correct. But my lord, that is because the stage has not yet come. My lord, what
Yes.
we have to first do is, my lord, give a notice, my lord, terminating the tenancy.
Yes.
My lord, my lord, estate officer is, my lord, really activated, my lord, by that notice. Thereafter, my lord, if he finds that there is substance in the notice saying that, my lord, there is an unauthorized construction and occupation, my lord, and occupant, then, my lord, he issues the notice under Section 4. But that is also, my lord, the finding of a, my lord, division bench of our High Court. My lord, because, my lord, first, my lord, notice terminating the tenancy, approach to the estate officer forms an opinion on the basis of notice as to whether there's any case at all, my lord, to proceed to issue a notice, my lord, under Section 4, and then, my lord, the matter proceeds to adjudication.
Yes.
My lord, that is, my
No,
lord,
but
part.
were you asked to, Mr. Jena was here. What was
here,
the
my lord.
instruction?
Well, your lordship asked us to, my lord, give a computation of our dues.
Yes, the quantum of rent.
Yes,
Yes, my lord,
Quantum of
that,
rent which the petitioners were required to pay.
my lord, the rent situation is that, my lord, as far as we are concerned, we have paid in excess of 4.5 crores. They have not granted us, my lord, the lease. They have not granted us permissions to put up
4.5
structures.
crores from when to when?
My lord, we put up, we paid the rents, my lord, up to the year 2019. Subsequently, my lord, there were 2 years during which COVID moratorium was extended across the board, also by the port
2019
authorities.
to 2023, how much are you supposed to pay?
My lord,
At the same rate.
if that moratorium is off, my lord, we are required to pay at around, my lord,
Moratorium is off?
I mean, the two-year moratorium that they have given across the board to everyone, my lord, for those, my lord, because of the COVID period.
Yes.
Beyond that, and adding this together, we'll be about a crore and 30 lakhs of rupees, my lord, which would be payable if the rent
1.30 crores.
1.30 crores, my lord.
Yes, Mr. Shah.
according to our estimation, my lord, following the TAMP, my lord, notifications, my lord, presently, my lord, for the 3, my lord, plots, 12 crores, 19,73,964 is due. My lord, that is, my lord, proceeding of the yearly rents as determined by TAMP.
Yes.
At the TAMP method, my lord, what they have done is they have, my lord, computed a particular payment which is supposed to be made, calculated interest on the basis
No,
thereof.
Mr. Banerjee, at the rate of which you were paying till 2019,
At the
what
rate-
would that rate be?
That rate would be, my lord, minus the moratorium 1.30.
Well, there is no moratorium
No, no,
period that is
no,
extended.
including the moratorium. You just take the moratorium away. How much would that be?
That would be close to around something around 4.5 crores, close to 4.5 crores,
4.5 crores.
close to 4.5 crores.
Very well. You give 4 crores. I'm giving you the temporary stay of that.
Not only one
Well,
frame, my lord,
well,
we had
only
to-
one thing, my lord.
only 2 aspects.
Stay of, my lord, notice
Two aspects.
Yes.
of eviction, my lord,
Yes.
that, my lord, is, my lord, perhaps there is no basis for that, because,
no.
my lord, your lordships have held that, my lord, so far as that is concerned, that is a matter for adjudication for the estate officer. All that I have done for the present is merely terminated, my lord, the tenancies.
No,
by
we
notice
are
to
not
quit.
standing in the way of
Mr.
termination.
One, please. Mr. Shah, the 4-1 procedure has not been followed.
Well, 4-1 procedure, my lord, is not yet, my lord, the stage has not yet come.
But
Well,
that-
that is what I want to show you, lordship. Well, I don't have to follow a 4-1 procedure before I
Very
serve
well,
a
very
notice
well.
to
But they are
quit.
trying to
Then
dispossess
I
us.
will say this, Mr. Banerjee, you
I'm
will speak only when I ask you to.
I'm sorry. I'm
Mr. Shah, you do this.
My lord.
I'm going to make it very clear because either way it has to be decided. 4 crores payment.
Yes.
You will not take any steps pursuant to that notice unless you follow the procedure under 4-1.
Yes,
All right.
yes. My lord, I will, my lord, of course, I can't, my lord, summarily evict them. That is, my lord, absolutely
Yes.
There's only one prayer, my lord, very humbly, my lord, if your lordship, my lord, permits us. My lord, all these 3 lands have been lying fallow because of the fact that the port had not granted us permissions, my lord, to put up structures. We have not been able to put this to any gainful use at all. We've made payment of rents for 3 whole years. My lord, we have made payment of the entire initial
Yes, what
security
is it that
deposit.
you want?
Would your lordship, my lord, kindly, my lord, if your lordship kindly considers, my lord, permit us, my lord, to pay, my lord, some amount lesser than what your lordship has just held. 4 crores altogether now would put us out of business, straight away out of
Well,
business.
I say that
The entire 3 lands are fallow. Mr. Shah will appreciate. Entire 3 lands have been rendered fallow, not due to my disuse or non-use. It's because of non-grant of permission of the port. Port didn't register 2 of the lands, despite our repeated going there. The first one which was registered, they didn't grant us permission to put up structures. We've given our plan in 2019. It is 2020.
Your lordship is being asked to modify the terms of the lease.
No. Just by way of an interim measure, my lord is directing certain
Where
payments.
is the impugned notice?
Yes.
Page 150.
Well, there are 3 notices. My lord, all just notices to quit. My lord, thereafter, my lord, naturally, my lord, 4-1 will be, my lord, either, my lord, invoked by the estate office or not invoked.
It was Mr. Jenna's submission yesterday that they had come on
174.
13th of April 2023 to get us out of possession. That was his specific submission. That's recorded in yesterday's order.
I absolutely concede
The
that my lord,
building plan, my lord, at
due
1-1.
process has to be followed. But the
Yes,
process of the eviction of unauthorized
The
occupants
impugned
act.
notices, this matter was partially heard yesterday. Stop. The impugned notices issued by the estate manager of the SMP / respondent, answering respondent, on various dates on 14/3/2023, 12/4/2023, 23/3/2023, and 14/3/2023 and 23/3/2023 দেখে নেবে ফ্ল্যাগ করা আছে, were issued without complying with the requirements, the procedural requirement.
Kindly bear with me for just one moment. Just any one notice. Kindly see the last paragraph. Well, for example, if your lordship sees page 176, the notices are identical. Kindly see, my lord, just before the schedule of property, the last paragraph.
Yes.
It may be mentioned that there is no alternative but to place the matter before the learned estate officer, the adjudicating authority under the PP Act, in case of default in compliance with the above notice.
Mr. Shah, I'm just going to say, but look at the other ones. They are for eviction. Clear.
Eviction, but my lord, only my lord,
Yes,
notice to quit has to be, my lord, followed by a notice under my lord 4-1. And my lord, that is a division being judgment of our court.
You cannot dispossess us.
My lord, if your lordship wants, my lord, may I?
Yes, without
judgment.
complying with the procedural requirement set out under section 4 within brackets 1 of the 1971 Act. Stop. Since, learned counsel appearing for the respondent port submits that the stage for compliance under section 4 within brackets 1 has not been reached as yet, it is expected that the respondent shall not give any effect to the said notices or take any steps in pursuance thereof until
Except my lord, to approve
the
the estate
respondent until the respondent follows the statutory procedure.
Obliged, your lordship.
Stop. Next, it is also admitted that the petitioner number 1 has paid the lease rent since 2019. Stop. There is a dispute as to the quantum payable by the petitioner until up to 30/4/2023. Stop. The petitioner says it should be about 1.3 crores, while the respondent says it should be 12 crores. Stop. Next, until the matter is further considered on affidavits, the petitioner shall pay an amount of rupees 3 crores to the respondent. Which respondent?
Respondent number 1, my lord, is the
To the respondent number 1, which shall be done within, yes, what is a good time?
kindly give me a month's time, my lord.
No.
3 weeks, my lord.
Yes, which shall be done, done by 12/5/2023.
Obliged, my lord.
Stop. Next, affidavits in opposition. Now, it is made clear that this amount shall not result in any equitable considerations in favor of either of the parties before the court.
Obliged.
Stop. Next, affidavit in opposition within
3 weeks, my lord.
3 weeks, reply within a week thereafter. List this matter on June 7th.
Only one
2023.
clarification.
Only one.
Well, if your lordship will kindly, my lord, clarify that this order will not prevent me from, my lord, approaching, my lord, the estate officer, my lord, for issuance of notices under section 4.
Yes, needless to say, the respondents shall not be precluded, PRECLUDD, precluded from taking from following the statutory mandate under the 1971 Act.
Only one prayer, my lord. The payment that we have made are without prejudice to our rights and contentions.
Yes, the payment, agir paragraph korda, the payment shall be made without prejudice.
Obliged, lordship, deeply obliged.
Next.
Item 13, item 13.
My lord, I appear for the petitioner, my lord.
I appear for the
Lordship was hearing this matter yesterday, my lord. The issue
Yes,
was, my lord, this,
WBIDC.
My lord, I appear for the respondent WBIDC, my lord.
Yes.
my lord, the issue was, my lord, the non-disbursement, my lord, or refusal to disburse incentives under the 2008 scheme.
Yes.
My lord, the admitted position is that there is a registration certificate in part 1. In part 2, I had applied for, my lord, my lord, the commencement of the, my lord, commercial production. My lord, that certificate is there. I commenced production. I applied for certificates from the VAT authority. I get that, and I then apply for the, my lord, incentive. And till 2016, my lord, I was given the incentive. Now, balance, my lord, they refuse only on the ground by the impugned order, only on the ground that there has been a change in law. My lord, I understand there is no scope of an interim order in this writ petition. Lordship would, my lord, issue directions for affidavit. Only one prayer I had, my lord. I filed a supplementary affidavit yesterday disclosing, my lord, a notice, my lord, issued by the authority, my lord, where, my lord, they were alleging violation of a particular clause. My lord, my contention before your lordship would be that that stage is long gone, and lordship would consider whether there is a violation or not whenever lordship ultimately decides.
No,
My lord,
how does it hurt you? 7.2?
My lord, it does not hurt me immediately, but I am required to attend a hearing before the authority. My lord, after the authority accepted the certificates, my lord, accepted the date of, my lord, commencement of commercial production, issued, my lord, the VAT certificates and disbursed payments. Now they want to go back. There is a provision in the, my lord, scheme which says that that can be relaxed also. So this issue also lordship considers. I should not be, my lord, asked to go back to the authority. This violation issue, lordship can reserve it for consideration as and when lordship decides the writ petition.
We have asked him to, my lord, only we have asked him to participate in the proceeding, my lord. He has to just
No,
demonstrate.
what proceeding is this?
My lord, with whether at all there has been any violation, whether at all there has been any violation of clause 7.2 of the scheme
Now
or not.
that the matter is before the court, what will you consider?
My lord, this is only with regard to, my lord, whether this
No,
RC2
will that adjudication have a bearing on the petitioner's eligibility under the scheme?
my lord, because the petitioner has been granted RC2 eligibility certificate.
Mr. Siddiqui, then obviously you can't do it anymore now that you are before the court. Because the petitioner wants incentives under the scheme.
My lord.
You are proposing to call the petitioner for a hearing
My lord.
as to some violation which the petitioner may have done, may not have done under a particular clause,
My lord.
which will have an impact on the petitioner's eligibility
My lord.
for the scheme.
My lord.
Wait.
My lord, only thing, my lord, your lordship may kindly appreciate, my lord, subject to your lordship's sanction, my lord. Clause 7.2, my lord, grants me the right to issue eligibility certificate under RC2 to the petitioner, my lord. We are only to check whether we have rightfully issued that RC2 to the petitioner or not, my lord. Only for that. Only for that purpose.
Suppose you come to a conclusion that it was not done.
It was not
properly done. Then what?
Then he would
Then
not have.
the writ petition becomes infructuous.
Then he would not have been entitled to this amount, my lord, of this subsidy. Then, my lord, he will have a new cause of action.
Party, the court will hear you. You wait. there is no scope for an interim order since the petitioner's claim arises out of a scheme of an incentive scheme capitals floated by the state government when
My lord, 2008 scheme, my lord, this is my lord.
in 2008. Stop. The petitioner seeks the benefit under the scheme to the extent of being issued the RC2. Is that correct?
That is correct. And my lord, they have certified, my lord, the VAT certificates have been issued, which gives me the eligibility to receive the quantum of incentive.
RC2. Stop. The petitioner says that the petitioner has received certified copies of VAT certificates, which further entitles the petitioner to the benefits under the scheme. Stop. Next, the petitioner's immediate concern is a notice issued by the Directorate of Industries on 30/3/2023, asking the petitioner to come for asking the petitioner to appear in a hearing, to participate in a hearing for the alleged violation of clause 7.2 of the scheme, capital S. Stop. The petitioner does not intend to participate in the hearing pending final adjudication of the writ petition. Stop. Next, affidavit in opposition within Mr. Siddiqui.
Within 4 weeks.
Within 4 weeks as prayed for. Reply within
2 weeks thereafter.
2 weeks thereafter. List this matter after 6 weeks. Stop. The respondent, the answering respondent shall not proceed in terms, shall not expect the petitioner to participate in a hearing or give effect to the notice dated 30/3/2023 or similar notices issued by the said respondent until the matter is finally heard out and decided by this court.
I'm grateful, my lord. My lord, that answering respondent should be respondent number 2, my lord.
Answering respondent / respondent number 2.
Grateful.
My lord, only one aspirant, affidavit in opposition to both the writ petition and the supplementary affidavit.
Yes.
The respondents shall be at liberty of filing an opposition to the writ petition as well as a supplementary affidavit.
Deeply
I'm
obliged.
grateful.
Item number 14. I picked up here for the petitioner, my lord. The petitioner had, my lord, challenged, my lord, the lookout notice issued by the State Bank of India. But the lookout notice issued by the State Bank of India against my petitioner, my lord, that is under challenge before your lordship, my lord. Now, my lord, what happened, my lord? There is no criminal case pending against me, my lord.
There is
no criminal case pending against me, my lord. Only, my lord, in 2018, my lord, section 7 of bankruptcy, my lord, but that resolution is
I can't understand. Speak clearly in the microphone. Yes.
Section 7 of bankruptcy code, my lord, was filed, my lord, against my company, my lord, in which I was a director.
Bankruptcy code, IBC.
IBC, my lord. IBC,
Yes.
my lord. And my lord, that company got resolution, my lord, and it was disposed of in 2019.
Yes.
So, my lord, that order, my lord, your lordship will find, my lord, page 20, my lord. And my lord, your lordship will find, my lord, the relevant.
So what was disposed of?
This was disposed of in 2019. Against this, my lord, they are issuing this one. They are issuing.
What is the interim order you want?
Interim order, my lord, I want to go to foreign, my lord, and my lord,
You want to go where?
Your lordship will see, my lord, your lordship order.
Where do you want to go?
I to Vietnam, my lord. Vietnam, my lord. And your lordship will also find, my lord, your lordship's order is there, my lord, where my lord, your lordship had asked them, my lord, to give reason why whether lookout notice was issued against us or not, my lord. That your lordship will find at page 37, my lord. Kindly see, my lord.
The same petition is back before the court.
No, my lord, the same petitioner, because, my lord, the lookout notice, my lord, they have
Page
37, my lord, relevant portion, page 38. But kindly see, my lord, after hearing the council, the writ petition is disposed of with a direction upon the respondent number 3 to respond by a letter for the petitioner to 7 days within time. The reply should reach within 21st March 2022. My lord, this, my lord, was disposed of, my lord, by page 39, my lord. Kindly see, my lord, what they have sent. They have sent just instruction, my lord, which they have given to the learned advocate. My lord,
No,
see, my lord,
reply to what?
my lord, reply to our representation, my lord. They did not bother, my lord, to give any reply to our representation, my lord. Only they sent, my lord, just, my lord, instruction which they have handed over
What
to the
is FR, Foreigners Regional Registration Office?
registration office, my lord.
Yes.
Kindly see, this is subject to instruction in respect of WP number 2227 of 2023. From here, my lord, I find, my lord, para 2, my lord, kindly see that LOC, last line I am praying, my lord, LOC issued against Avinash Jaswara Jawar, issued at the behest of State Bank of India. Now, my lord, today, my lord, I will ask, my
No,
lord,
who is before the court?
this Avinash Jawar, my lord. He is before the court, my lord.
So this says there is no LOC issued against, no, the one LOC against Avinash Jawar.
Jawar, my lord.
Yes.
Now, my lord, they did not give us, my lord, the reason why this LOC has been issued, my lord. My lord, I have a judgment to show, my lord, this
Very
basic
well.
of
Yes,
LOC,
yes,
my lord.
Mr.
Lord,
What do you have to say?
Lord, at least there are 6 judgments, Lord, against me. More than 6 judgments, Lord, against me on this point, Lord.
But what is the one judgment which is your ace?
Lord, it's not there. That is
Not
what,
there.
Lord, I would like to argue, my lord. I would like to argue, my lord, if your
No,
lordship.
no, what is the point which you want to argue?
My lord,
I will hear you with pleasure, but what is the point?
my lord, in all the judgments.
I'm not
Lord,
saying what is the point of argument. I'm saying what is the point which you want to argue?
yes, my lord. In all the judgments, my lord, that have held against the banks, my lord, the points which have found favor
Microphone,
with the
please.
the
Yes.
points which have found favor with the court is that, my lord, default committed by a borrower,
Yes.
irrespective of the amount, my lord, it does not have impact on the economic interest. This is one of the points, my lord, which has been found favor with the courts. Although, my lord, LOCs are supposed to be issued, my lord, in terms of the office memorandum, where, my lord, the bank's chairman and the executive directors have been, my lord, granted power. My lord, that office memorandum has not been challenged. That is a law, my lord, under my lord, Article 13 of the Constitution of India. My lord, Article 21, my lord, says that you cannot be restrained, or, my lord, personal liberty, my lord, cannot be inhibited except in accordance with procedure established by law. My lord, if this is law, which qualifies for the definition of law under Article 13 of the Constitution of India, it has not been set aside, not has been spoken against by any court of law. Rather, my lord, there are judgments which find favor with this. Then in that case, my lord, this is a restriction.
What is the law according to you?
My lord, the law, my lord, which says the office memorandum which my lord strengthens or, my lord, fortifies the banks, my lord, to request for issuance of LOCs in cases where, my lord, there are economic interest hampering things which have taken place, my lord.
Yes.
Which take place, my lord, which have effect on the economic interest, my lord. There are willful defaulters, my lord, where, my lord, amounts in excess of rupees 50 crore, my lord, have been defaulted. My lord, the accounts have been declared to be fraudulent, fraud declared accounts. My lord, there are petitioners.
Mr. Rai, hasn't the Supreme Court recently said that before an account is declared as fraud, then you must give a hearing?
That is there.
I think the CGI and Justice Narasimha.
The recent, yes, my lord. The recent judgment, my lord, says so. It says so, my lord. But here in this case, my lord, account has been declared fraud. The borrower has not challenged. Somebody has to come and challenge. Even if there is no hearing, my lord, somebody has to come and challenge. My lord, post, my lord, this judgment, if somebody comes and challenge, my lord, he'll be a fence sitter, my lord, because somebody, my lord, had the courage to say that I need a hearing, and he went up to the court. My lord, your lordship is aware, my lord, from Roop Diamonds 81 Supreme Court till, my lord, the recent trend, my lord, fence sitters will not be, my lord, blessed with. My lord, in my
What makes you think the petitioner is a fence sitter? The petitioner has been issued an LOC.
My lord, he has been issued an LOC. His account has also been declared as a fraud. He is a willful defaulter also, my lord. None of these proceedings have been challenged. My lord, fraud declared long back. Willful defaulter, my lord, I have instructions, my lord, in 2020. My lord, in 2023, my lord, till 2023, my lord, there is no challenge. My lord, thrown to the willful defaulter declaration proceedings. My lord, he is a willful defaulter. My lord, amount in excess of 64 crore. My lord, is due and owing. My lord, fraud declared accounts.
So according to you, 64 crore is not a pittance.
It should not be, my lord.
Should not be.
My lord.
Usually the cases which come are in excess of 500 crores.
My lord, that
at least in relation to LOCs.
Milord, if 64 crore, Milord, multiplied by 5 people, Milord, who have been allowed to go abroad, Milord, and they settle, Milord, it will come to some of that figure, Milord, somewhere close to that, Milord. Your Lordship will have this view, Milord, but I would like to argue this, Milord, subject to your Lordship's convenience, Milord, if your Lordship kindly grants me, Milord, and if my learned friend
And
does not
what
have
happens to the petitioner wanting to go to Vietnam? You may argue the matter. You may want to argue the matter and take your time.
No,
But the
Milord, I
petitioner
will
wants to
come
go to
back.
Vietnam.
Milord, if
What
he
happens
doesn't
to
want
that?
to go tomorrow, Milord, or by Monday, Milord, on Monday, if your Lordship wishes to hear me, Milord, if
You want to go, you want him to go and return by Monday. What is it that you want?
Lord, Lord, I don't know, Milord, whether he wants to go by Monday or after that, Lord. If he goes after that, Lord, Monday will.
Now, my lord,
Lord, there is no
And-
date mentioned in the writ petition. Lord, the writ petition does not also speak about what business the petitioner does, why he wants to go over there. Lord, he says that he wants to go there for business. What businesses does, we don't know. Now, Lord,
Yes.
these are some facts which, Lord, in my very respectful submission in these types of cases, Lord, where there are apprehensions. Lord, all these things, Lord, were not there. They came, Lord, post Nirav Modi. Lord, this is a fact. Lord, in 2017, Lord, when that
Or
happened.
rather, you woke up after Malia. Yes.
Lord, I'm yet to wake up, Lord, Mondays.
Yes.
Lord, if your Lordship, Lord, gives me time till Monday, Lord, I can come, Lord, subject to your Lordship's convenience, Lord, and subject to, Lord, my learned friend's urgency.
now, my lord, here, my lord, I have a
Don't go now. You go later.
my lord, on May, I have to go, my lord,
What?
for business opportunity, my lord. After this May, I have,
But you haven't traveled for such a long time. Why do you have to go in May now?
my lord, while the matter was pending before the NCLT, my lord, I was free to go, my lord. When the matter got disposed of, my lord, thereafter I have been arrested, my lord. See, my lord, I have a judgment which says, my lord, if my lord, my going to foreign is detrimental to the economic of India, my lord, then only I can be stopped, my lord. Or if it is detrimental to the sovereignty or security of India, my lord, then I can be stopped, my lord. They have to give reason, my lord, why NSP, this lookout notice had been issued against me, my lord. I also need to be heard, my lord. Nothing has been done, my lord. Only, my lord, I come, my lord,
No,
from my uncle.
lookout circular, the memorandum says you don't have to be, there's no requirement of hearing.
There's no
That's the
requirement of
memorandum.
hearing.
Have you challenged it? Or you don't know what the memorandum says?
The memorandum they have not supplied to us, my lord. Your lordship order was that, my lord, to give us that what is pending against us. But they only handed over, my lord, the instruction which they have given to their advocate. Kindly see, my lord, that is the thing. They have not followed your lordship's order also, my lord. I've showed to your lordship that, my lord. So, my lord, first they have to say, my lord, why, my lord, if I go to foreign, my lord, what will happen, my lord?
Don't say foreign, please.
To Vietnam, my lord. Sorry, to Vietnam.
Yes.
To Vietnam, my lord.
Yes.
My lord, they have taken my factory, my lord. They have taken my company also, my lord. The another company is there, my lord. But I have given all my debt, my lord. Now, my lord, I want to do business, my lord. Even if I don't do business, my lord, how can I pay their debt, my lord? If there is debt, some debt is there, my lord.
So what have you been doing all this while? Not paying them? You're
No,
not
we
doing
have
any
paid
business?
them, my lord. We have paid them, my lord. Whatever
So
capital we had,
you will do business only in Vietnam, not in India?
we were doing over here also. We are doing here also, my lord. My lord, for searching business opportunity, my lord, we want to go to Vietnam. my lord.
Mr. Rai, do they file a declaration undertaking and go for a short while?
Your
Or
This court has allowed us,
as
my
an
lord.
interim
Allowed
measure,
one of
my
the
lord,
parties, my lord. In this matter, my lord, this court has allowed one of the parties to go, my lord. That is what annexed with this.
but there's no date, no particulars, nothing. I only accept it on an undertaking given with the air tickets enclosed,
My lord, we
the
shall
reason
give,
for travel,
we
everything.
shall give that same undertaking, my lord, to the originator, my lord, where we are going, how
No,
many
my lord,
days we
in
will
court, my
be
lord,
there,
let this
and when we will
undertaking be in
return, my lord.
court, my lord.
We are
Originator,
ready
my
to
lord.
give that undertaking, my lord, before this court also.
How many of you are planning to travel?
But here, my lord, one, my lord. I stand corrected, my lord. My lord, kindly seize, my lord, page first annexure.
Very
my lord,
well.
this
You
court has
file
allowed.
that undertaking first and then I will hear the matter on merits. When was the LOC issued?
LOC, my lord, that's not given to the, my lord. We don't know, my lord.
No. When were you deboarded? When were you prevented from travel?
Lord, he has
My
not
lord,
traveled. That is not the
but
case in
my-
the writ petition.
Not travel.
the
Then how
directors-
do you know that you will be prevented?
Because, my lord, one of my directors, my lord, who went to Vietnam, my lord, he had been stopped, my lord. That's why, my lord. But I have made that case out, my lord. My uncle want to go to Vietnam, my lord. He was stopped. Thereafter, he has to come to High
No,
Court, my
but
lord.
what is your relationship with the company?
But I am also a director of the same company. Same
Present director,
No,
not
no,
erstwhile.
was a director. I was a director. Now this company, my lord, has been-
Erstwhile.
Erstwhile.
When did you resign?
My lord, that company was taken away, my lord, by
What's
IBC.
the
my lord.
company taken away? Is it a suitcase or what?
No, my lord.
Yes.
Section 7 of IBC code, my lord. Resolution. Kindly see this order, my lord.
Yes.
Annex P2, my lord. Kindly come to.
Very well. Just give me the facts, please, for the order. When was the LOC issued?
LOC, my lord, they don't say the date, my lord, in their reply. my
Very
lord.
well. You better come back ready, Mr. Arifin. You're not ready
But
with
they
the
have not
facts.
given the date, my lord. How can I say the date, my lord? They have not given the
Very
date.
well. So it's an apprehension of being prevented.
Yes, my lord. Apprehension of being prevented, my lord. Fine.
Yes, the petitioner claims to be an erstwhile director of the company in liquidation.
No, my lord.
In
The company
liquidation.
is not, no, no.
Liquidation already over, my lord.
Of a
Resolution-
company which survived a CIRP and emerged therefrom in 2019. Stop. The petitioner apprehends that the petitioner will not be allowed to leave the country on the ground that the petitioner's family members, who were also erstwhile directors of the same company, were prevented from traveling abroad. Stop. Next, learned counsel appearing for the respondent, State Bank of India.
Yes.
Respondent bank / originator submits that submits that counsel would like to argue the matter on a point of law. Stop. Counsel, however, okay, Kiran. Next, list this matter on when will you get that undertaking ready?
My lord, day after, on Monday, my lord, within this Monday.
List this matter on 1st May 2023 for the petitioner to file a declaration / undertaking in the form which is usually accepted by the court. Stop. Also, evidence of the reason for travel.
Mine.
Next.
Grateful. Item number 15.
Lordship, I appear for the petitioner. Lordship, on the last occasion when the matter was taken up, your lordship's your lordship's pleasure was that we should address your lordship on the maintainability, as the contract, your lordship, has an arbitration clause, your lordship.
Yes.
I'll just, your lordship, indicate few facts. The petitioner, your lordship, carries on the business of lifting and selling dry fly ash, your lordship, under the name of Satyam Sales. And your lordship, there was a notification of 14 September 1999, which permitted, issued by Ministry
Yes,
of Environment.
I remember that now they plan to auction the process.
Yes.
And whatever agreement you had, you were not supposed to pay anything.
No, 6 rupees.
6 rupees.
Yes.
And now they will auction the process of
Now they
lifting
say
the.
that the agreement has to be amended and you have to buy as per the e-auction process.
So you're challenging the proposal
Challenging
for
that
auction.
letter, your lordship, of 19th July 2022, whereby they have stopped giving us the dry fly ash. Stopped us from lifting the dry fly ash, your lordship. And though the dry fly ash, your lordship, the fly ash, your lordship, to evacuate it, they are the expenditure in worth of crores, your lordship, 90 crores as far as 2022 is concerned, and they're not supplying to us. In spite of the fact
what
that
do
we
you
have
say?
an
You have
agreement.
expended 90 crores.
The DVC, your lordship,
Yes.
the ash, your lordship, as it is, your lordship, considered hazardous to the environment. So there is a notification whereby they have to utilize that ash 100%. Now, what they are doing, your lordship, as they are note takers for that ash, they are incurring expenditure on transportation and giving it free to the parties, your lordship. And I have, your lordship, annexed those data, your lordship,
Very
which
well.
I have received from RTI.
Yes. What was the
And-
maintainability point? Who was arguing that?
The petitioners were arguing
Your lordship, in the
How can the petitioner argue?
we were arguing, your lordship, in the reply, they had taken the point that this is not maintainable.
Yes. What was the point taken on the maintenance?
Because, your lordship, in that agreement, there is a clause which says there's an arbitration clause.
Yes.
And for that purpose, your lordship, I'll be relying on your lordship's order only on Radhesham Pandey versus Union of India, wherein there was an arbitration clause, and your lordship has considered the judgments of the Supreme Court, and your lordship has held that if there is, the act is arbitrary, then your lordship can look into it, Your Lordship. Take it as far as Article 226.
I
is
must have
concerned.
relied on that Harbanslal Sahania.
Harbansal, yes. I'll
Yes.
just, Your Lordship, take that.
Ms. Bhuteria, please, I don't have much time today. So just the judgment and you can conclude your submissions in 5 minutes.
Your Lordship, this is Your Lordship's time.
Just answer the point of maintainability, that's all.
Yes. No, Your Lordship, if I can show to Your Lordship, the
I don't
action
even see my
is-
judgment. Harbanslal
Yes.
Sahania is clear.
No,
clear.
Lordship,
Yes.
as per the agreement, they
Yes.
had to supply.
Yes.
In their, when they give us a notice, Your Lordship, saying that we are not going to supply, because at that point
Ms.
of time,
Bhuteria, not on the merits today.
yes,
Maintainability, you're relying on Harbanslal Sahania.
yes.
That's all?
So, Your Lordship, what I'm saying is that it is arbitrary, Your Lordship, the act of DVC by not permitting us to lift the dry fly ash, the grounds which they have mentioned are completely
Harbanslal
arbitrary.
Sahania had relied, if I remember correctly, on Whirlpool.
Yes,
Under which of the 3 or 4 conditions are you
Your Lordship,
coming in?
and it's arbitrary. The act of the state is arbitrary. And Your Lordship, in the second, Your Lordship, that the legitimate.
Was that one of the 4?
Your Lordship, with a
No.
fundamental right, if it violates your.
Fundamental rights, jurisdiction,
yes.
natural justice.
Yes. No, Your Lordship, there's no hearing given to us. They have issued a letter saying that we will not permit you to lift dry fly ash on these grounds. And if you want it, then you have the agreement.
What
has
is your
to be
fundamental
amended.
right?
No, Your Lordship, I'm carrying on business of lifting this dry fly ash under an agreement without any reasons. They have stopped us from lifting dry fly ash. And on the other
Ms.
hand,
Bhuteria, come to
Yes.
the only Harbanslal Sahania and Whirlpool. Under which of those 3 or 4 are you
Your
coming
Lordship,
under?
I'm saying this act is arbitrary.
Arbitrary? No, that is not one of the 4 points.
If your
It is fundamental rights, ultra vires, natural justice. These 3 I remember.
Your Lordship, the principle of natural justice will come in, Your Lordship, because there's no hearing given to me as far as this, when they have stopped this. And Your Lordship, 19(1)(g), Your Lordship, this is my right to carry on the business, Your Lordship. And Article 14, Your Lordship,
Why is it an Article 14?
unfair, Your Lordship,
Unfair.
unfair, Your Lordship.
Don't say unfair. Please say something
Now, Your
more.
Lordship, that is what, Your Lordship, what I was indicating,
Is
Your
it
Lordship.
discriminatory? Is it what is it?
It is discriminatory. Your
How?
No, that's what they are, Your Lordship, selling they are, Your Lordship, giving this fly ash free of cost to others and incurring expenditure. And in spite of me having an agreement, they have refused to supply me, Your Lordship.
Very well. That is all. Anything more you want to say?
Your Lordship,
There are other.
Mr. Dhruva Ghosh is appearing in
Yes,
this
he's
matter.
already argued. Yes,
Your Lordship. So this is on the maintainability, Your Lordship, that even if an alternate
that is enough.
remedy is
Only on the
there,
maintainability. Yes. The respondent DVC has raised a question of maintainability of the writ petition. Stop. According to learned counsel appearing for the DVC, the writ petition is not maintainable as the agreement between the parties contains an arbitration clause. Stop. Next. It is well settled that presence of an arbitration clause is no longer considered to be a ground to preempt interference of a court under Article 226 of the Constitution. Stop. Harbanslal Sahania, which page of my judgment mentions it?
page
Which page?
5, paragraph 6. Page 5, paragraph 6.
Yes. Harbanslal Sahania versus Indian Oil Corporation, 2003 2 SCC 107, specifically dealt with this aspect. Stop. The said judgment also relied on Whirlpool Corporation versus Registrar of Trademarks, 1998 8 SCC 1. Stop. The consensus appears to be that the rule excluding writ petitions on the ground of alternative remedy is more a rule of discretion than one of compulsion. Stop. This is the Supreme Court in Unitech Limited versus Telangana State Industrial Infrastructure Corporation, 2021 SCC Online, SC 99. Recently opined that recourse to a public law remedy, despite the presence of an arbitration clause, is required to be decided on the facts of the individual case, on the particular facts of the case. Page 5 of page. All these decisions were were considered in a judgment of this court in Radhesham Pandey versus Union of India in WPA 10668 of 2021, which has been relied on by learned counsel appearing for the petitioner. Petitioner, stop. Next, even otherwise, comma. The petitioner's rights under Article 19 within brackets 1 within brackets small g of the Constitution have been infringed since the impugned action of the DVC has a direct bearing on the petitioner's right to carry on business, carry on trade and business. Stop. The petitioner also complains of violation of Article 14 of the Constitution on the ground that DVC is, what do you say, delivering?
They are, yes, they're delivering.
They are delivering delivering fly ash to other persons free of cost, while
and incurring expenditure.
Free of cost and incurring expenses for doing so, while taking a totally different stand in respect of the petitioner. Stop. Next, these grounds are sufficient to hold that the writ petition is maintainable. Stop. Next, the issue of maintainability is hence decided in favor of the petitioner. Stop. Next, when will you come back for the merits?
Your Lordship, next week, Your Lordship, on
List this matter on 15th May 2023 to hear learned counsel of the parties on the merits of the matter.
the other points which they have taken, Your Lordship, that it cannot be a specific performance of contract and there is no public wrong. I'll address on that, Your Lordship, on the next.
Very well. Next.
Item number 16.
I appear on behalf of the petitioner.
Mr. Banerjee, any points I've not mentioned, which Mr. Ghosh? Yes, yes. Very well. Actor line likhe raho to the other contentions made on behalf of the respondent DVC will be considered after will be considered on the returnable date. Stop.
The issue is whether I can conduct a mela known as Boishaki Mela.
Boishaki Mela?
Mela.
But hasn't it gone already?
Milord, it was gone. It was decided in my favor. I am grateful to my lords. Now, Milord, your lordship may kindly consider, Milord, only 2 documents. I have
No, what do you want now? It's gone now. What
no,
Mela do you want to hold?
this is due to be, Milord, due to start from 25th, and Milord, it will last up to 9th of June 2023.
25th of which month?
25th of June.
June.
No, Milord, I say I stand wrong, Milord.
April.
25th of April till 9th.
Where do you want to hold the Mela?
Now, Milord, this is for the purpose of selling some articles and also, my lord, for conducting, my lord, certain ceremonies.
No, no, where, Mr.
In the,
Bhattacharya?
it is in the a particular, my lord, ground which is possessed by a college at Midnapur. And it is an old mela which is being conducted every year.
And who are you?
My lord, we are the students who are conducting the, we are
Students of what?
students and some are students, some are ex-students.
Mr. Bhattacharya, you're all the facts, you must be clear.
No, my lord,
Students of what?
Students at the college.
So say that. I
Yes,
don't
I'm
ask
sorry.
you so many
I'm sorry.
questions.
I'm sorry.
Yes, so why do the students suddenly want to hold a mela
No, my lord, this
and not
was
study?
this was no, my lord, this was the past practice. My lord, for a second, my lord, kindly consider, my lord, an order passed by a learned single judge. Just, my lord, few lines. Only, my lord,
Mr.
page
Bhattacharya,
35.
no. I want the students shouldn't be holding
No,
mela.
Millard,
They
I-
should be doing what they are supposed to
No,
do.
my lord, kindly consider. My lord, kindly consider that the students' union is holding the mela for a long, substantial time, and my lord, thereafter, your lordship may kindly consider.
So what is
that
the roadblock now?
the
Why are you
roadblock
before the
is
court?
a decision of the particular college. The college is imputing certain, my lord, ground, that is the area to be used for a mela is 5,000. That is, my lord, creating the obstacle because there is no law.
5,000.
5,000 square feet. My lord, this is the area to be used for the mela.
So what is the problem?
The problem is, my lord, that supposing, my lord, stalls are being installed. Now, my lord, this is just like a ceremonies, my lord,
5,000 square feet, you said.
square feet.
So that is a lot of space.
My lord, I submit, my lord, that the particular, my lord, the areas in which the particular stalls will be installed. My lord, there was no such,
So
my
how
lord.
much area how much space do you want?
My lord, this is a long, my lord, ground, my lord, which the college owns.
So
And,
you
my lord,
want the
this
whole
was
ground to
given
be taken up for the mela?
my lord,
No,
this is for the, my lord,
no, absolutely not. Yes.
Clarify it, my lord. Lord, this whole purpose to
Microphone.
the whole purpose to hold the mela
Who are you for?
for the governing body of the college.
Which college is this?
Lord, this is Prabhat Kumar College, which is in Kontai.
Yes, microphone.
Lord,
Yes.
whole purpose to conduct this mela to raise funds.
Yes.
This is the whole purpose. So
Raise funds for what?
raise funds for their own use, not paid to the the college.
Their own use means?
Because there is a some ex-student, they wanted to hold this mela to raise funds, so that they can collect money from the shopkeepers.
From the shopkeepers?
Yes, because in mela, there are a lot of shops will be installed.
Yes.
So they will raise fund, but they will not deposit any money to the college. But we have accepted that also.
So you're saying that they want to use the college grounds?
Yes, my lord. Now, second is this, my lord, the ladies' hostel, which is just 50 meters away from that mela ground. This is creating a huge problem.
Why?
My lord, the ladies' hostel is there, my lord, and the mela.
What?
And if the mela goes on in that area, my lord, 50 meters away
So
from.
what will happen to the ladies' hostel? What a sexist thing to say.
No. I'm saying that, my lord, the lot of, my lord,
So
unlawful.
there must be boys' hostels there also. So they will be fine.
But where the mela is, supposed
Yes.
to be held, just 50 meters away, there is a ladies' hostel.
So what? I'm asking you.
Lots of illegal activities is going on the mela premises, and lot of complaints was made to us.
In the mela premises?
Yes.
So why will the boys' hostels in the boys' hostel not be affected? Only the ladies will be
Boys'
affected.
hostel is not there, my lord. Boys' hostel is some distance. The ladies' hostel is situated near the mela ground, where they wanted to hold the mela. But kindly see that the single bench has directed
No,
some.
please. I'm not interested. Just tell me the merits of the matter. Yes.
My lord, we have given, my lord, kindly see page 10, the resolution taken by the governing body. Kindly see page 10, my lord. It is dated
Page 10.
P10, page 56.
But you have given them 5,000 square feet of space.
Yes, that
But
has
they
been
want
indicated
whole
in the
ground.
resolution.
Whole ground covers, my lord, the hostel premises also. My lord, which we have said we cannot allow it to the. And see our conditions, my lord, whether these are unreasonable or not.
Where is
Page
your letter?
57.
Page 57.
I don't know. These matters also come to the court. It's unbelievable. Page?
Page
57.
57.
The condition given by the, my lord, the managing committee as well as the, my lord, the other representative as per the direction of the court. Kindly see page 57. There will be no rent for using college gown for organizing the mela this year. We have given this proposal. The mela will be conducted for 45 days, which was earlier they used to conduct. Total area to be used 5,000 square feet. There will be no commercial stalls except the stall related to Rabindranath Tagore.
So Rabindranath Thakur is also a commercial stall.
No, no, no. Milord, commercial.
It
Milord,
says
is-
there will be no commercial stall except stalls related to Rabindranath Thakur. What does it mean?
Rabindranath Thakur, it means, Milord, they have not write it properly. Milord,
This the main purpose is political motivation. I want to
You
be
are the one who wants
excluded.
to hold the mala and you are saying political motivation.
No, I say, Miller, there is one man who is tailoring the entire issue.
What one?
Who is tailoring the entire issue? Now, Millard, I tell you, Lordships, Millard, your Lordship may kindly consider that, Millard, your Lordship knows, Millard, about the past practice. Now, Millard, past practice, Millard, shows that this was being performed for a long spell of time. Now, there was intervention
Mr.
of the court.
Bhattacharya,
Millard,
I am not in favor of students holding malas. Absolutely clear. And if you have been given 5,000 square feet, that's a lot of area, hold it over there.
Millard, only thing your Lordship may kindly consider, Millard, for a second, Millard, permit me to, Millard, kindly see the order, Millard, which was passed by the division bench. Or Millard, kindly see, Millard, single judge.
Just tell me the single judge, what he or
Millard,
she
the
had.
Honorable Single Judge Millard directed that, Millard, I'm just indicating your Lordship need not, Millard, go into the issue. The first single bench, Millard, indicates that the latent motivator behind such refusal is the grudge borne by the chairman of the municipality because of the previous refusal for permission to hold a different mela for the same period on the college. Thus, the chairman's inaction is a telling proof of his malafides.
Mr. Bhattacharya, I have a different view of students, what they are supposed to do.
No,
They are not supposed to be doing all these things. I don't endorse to the view.
No,
I'm very clear on that.
Millard,
No.
I leave it to the court. I leave
Yes.
it to the court, but only thing I say, Millard, that Millard, at least Millard, this particular mela should be conducted in a reasonable space. That Millard,
5,000 square feet is
Millard,
more than reasonable.
5,000 square feet, Millard, Lordship may kindly consider that this particular courtroom, what is the area of this particular?
I don't know. What is the area?
Millard, I say,
You tell
Millard,
me, what is the area?
Millard, it is around, Millard, it will be around 1,000 or
1,000. So 5 times this courtroom.
No.
I
say,
will
Millard,
make it. I will make it 2,000 square feet for you.
Millard, kindly consider that the reasonableness of a particular decision has to be, Millard, tested. Millard, he has I have challenged the legality of this.
Mr.
particular
Bhattacharya, I
decision.
don't find this unreasonable at all. They have given you 5,000 square feet. They have given you for 45 days of mela fun, whatever.
Yes.
All
Yes.
right.
With
And
that, with the
yes,
period,
they
I
have
am not
given you
saying- I
college
have
space.
nothing to.
You have your fun and you just get over and done with it. Yes. What is all this? And you come to the court for this. No.
And Millard, kindly see the next ground, Millard, that there will be no commercial stalls except the stalls related to Rabindranath Tagore. Then what for the mela will be
No,
conducted?
are you in court for interpretation of
I
this
am not
line?
interpreting, Millard.
No,
Kindly
because
see-
I am also not clear. So you tell me what this means. Yes, what does this mean?
It means, Milord, Milord, I am also confused, Milord, the sentence which is they have written, apart from
No, you want stalls of Rabindranath Thakur or you don't want? What is it that you want?
Milord, stalls, what they are saying, Milord, they are putting, Milord, what I say, Milord, the stalls relating to the commercial stalls, like Milord, they are selling, someone selling say utensils.
So that is fine. Then why pull in Rabindranath Thakur in this condition? I don't understand.
Lordship will come across one aberrament. This mala is being held. Page 10.
Because of the birthday of Rabindranath Tagore.
Vaishakhi mala is organized to spread.
But that is 9th May and you want to continue the mala till I don't know till when.
No, it is being done every year.
And Milord, college is
Being done
open
every
in the morning till evening. They want to hold the mala. Still, we have, as per the direction of the court, we have permitted them.
Yes. This is under challenge, 57.
Page 57.
That is only under challenge.
That is only 56 and 57.
The petitioners, how many of you?
Millard, there are
A lot of ex-students. None of them are present student, Milord.
The 5 petitioners before the court are ex-students of
But I have stated in paragraph 2A that they are the running students as well as the
students
ex-students.
of Prabhat Kumar College, Kontai, and are aggrieved by a letter, by proceedings of minutes, by proceedings of a meeting held by the governing body of the college on 24/4/2023 pursuant to a direction of who is the learned single judge?
My lord, the first honorable single judge was my lord, Mr. Justice Shobboshachi Bhattacharya. The second single judge was
Recently, Shampa Sarkar. Yes. Malayasi Shampa Sarkar. Recently, just few days back.
So Justice Sarkar allowed you, said that this.
It was
kindly
left to
see
the
this thing,
Keep on.
reflected in page 54.
Yes, pursuant to an order passed by a learned judge of this court. Stop. The petitioners claim to be aggrieved by imposition of certain restrictions, which would be reflected from the minutes of the proceedings. Stop. The petitioners are unhappy with the 5,000 square feet of space given to the petitioners for the quotation marks MELA, close brackets. Stop. The petitioners say that the restriction is unreasonable, that the restrictions are unreasonable, and the petitioners want a larger area to hold the MELA. Stop. MELA. Stop. Next. The governing body of the college is represented. Who are you appearing for, Mr. Galib? For the?
For the state.
Stop. Is represented, and so is the state. Stop.
I am for Jila Purishad, my lord, respond 3.
Next, after hearing learned counsel appearing for the petitioners, it appears that the petitioners have held this MELA on the college grounds where they were students at one point of time from?
This was conducted from 2000 just
for at least the last 10 years. Stop. Is that correct or not correct?
Correct.
For at least, because you don't even have an answer to the question.
More than 10 years.
For more than 10 years. Stop. The petitioners are of the view that the 5,000 square foot of space is not sufficient for the MELA, and want the entire college grounds for holding the MELA. Stop. The MELA is on the occasion, the MELA is described as quotation marks Boishakhi MELA, close quotation marks, and is intended to be held from 25/4/2023 till
9 June.
Till 9/6/2023. Stop. Next, the restrictions, even from on objective parameters, are reasonable. Stop. The college has willingly given, the college has willingly lent its grounds for erstwhile students to hold the MELA, and that too without asking for any rent. Stop. The only inexplicable condition is that there shall be no commercial stalls except the stalls related to Rabindranath Tagore. No theke Tagore, quotation marks, italics. Stop. This condition, the court is not, the court is also not clear about the implication of this condition. Stop. Next, apart from the objective assessment of the situation, even by subjective standards, the students are have been given the liberty, the petitioners have been given the liberty of holding the MELA, which claims to be seasonal, till the end till the end of summer. Stop. The 5,000 square feet of space allotted to the students is absolutely reasonable and is considered to be sufficient for the purpose of holding the Mela. Stop. There is no reason why the students would want a larger space for the Mela, even including for putting up commercial stalls. Stop. The governing body, however, needs to clarify what it means by what it meant by condition number D, condition choto D. Stop. Next, there is it is even arguable whether the petitioners could have approached the writ court against the decision of the governing body, since the petitioners really have no reason for complaint. Stop. There is nothing on record to indicate that the college has put further fetters on the petitioners in terms of their enjoyment of the duration of the Mela. Stop. The students in any event, next, WPA 10291 of 2023 is disposed of in terms of the above. Stop. The petitioners shall be at liberty of seeking clarification from the governing body of the college with regard to the condition as stated above. Stop. Stop.
Good.
Next. Yes, any other new motions which people are waiting for? Yes, Mr. Kormukar, which one?
18.
Parted. Which one?
18.
What is the urgency?
Termination order has been stayed by your lordship, and the IOCL authority is saying they will not make allotment.
So it's in your favor.
Termination order is stayed by your lordship.
Yes.
Now they are with to make allotment. They are saying since there is no.
Very well, you come back tomorrow. Yes, who else is waiting here for the new motions?
I'm coming from Bombay.
I can't understand what you're saying.
My lady, I'm a counsel appearing from. I'm a counsel appearing from Bombay. For
Bombay?
Yes, appearing in item number 48, my lady. It's
That you could have come through. You could have been been online. Why have you come physically?
No, I was not aware. Anyway, I've been told about it. So in case I can get a fixed hearing any time to the ladies' convenience, I can come.
Who is
I'll
your
not
other
take more than
side?
5 minutes.
Who is your other side? Very well. 48 to Shombadin Tuladao. Yes, Mr. Chatterjee, which one?
Lordship, I'm waiting. While a senior friend
Microphone.
is there from he's
From where?
appearing on
Some
behalf
other
of the
city?
respondent.
Yes.
My senior friend is appearing on behalf of the respondent bank. Now, Lordship, my prayer is very short, Lordship. Since DRT2 was not working, I filed this writ petition challenging.
No, now it's working. So you want to dispose of
The only problem which I am suffering, Lordship, this has been assigned to the bench which is there in Siliguri. Now, this is one
But
problem.
there must be online facilities. You don't have to go to Shiliguri.
Lordship,
Milord,
kindly-
regular matter is going on,
Sir, I
Milord,
will-
and I have got the entire April month's
even I have-
list.
What is it that
and
you
charge
want?
is
You
all
want
proceedings
to go to
regularly.
Siliguri? You don't want to go to Siliguri. What is it that you want?
Online facilities, if it is given, Lordship, we can proceed.
Online. DRT doesn't have online facilities.
Yes, yes.
Then,
Milord, I got the list,
Mr.
Milord.
Chatterjee,
Each and every day
wake
we are
up.
hearing, Milord.
You think the petitioners are expected to go to Siliguri for hearing of their matters? You want to go?
That is the only problem, Lordship. Otherwise, Lordship,
If you want to go, I will not interfere. What do you want?
I can go to Siliguri, but not now.
Milord, regular court is there, Milord, each and every day at 3 o'clock, and we have the list for the whole month, my lord. And sometimes, Milord, on the last occasion, also I have heard the court is not sitting, and under oath they are
Very well,
making
very
the
well.
application.
Mr. Chatterjee, I'm disposing of the writ petition.
Yes, ma'am.
16 to Dakato. 17.
Item number 17.
Yes, learned counsel appearing for the parties agree that the writ petition may be disposed of on the ground of the concerned DRT now functioning.
Lordship, now, Mr. Saha is saying that from 1st May to 4th May, DRT2 is physically sitting in Kolkata. Lordship, only one indulgence. If the matter is placed, By this time, Lordship, it may be taken up by that.
They may approach.
Why can't you go to the DRT,
I will.
Mr. Chatterjee? Yes. Nothing further, therefore, comma, nothing further remains of the writ petition. WPA 9997 of 2023 is disposed of in terms of the above.
Affidavit of service
Yes.
be kept with it.
Yes, after service. So next, any other matter where people have, hurry up, please. Yes, Mr. Chatterjee, which one? Very well, Pathard. Mr. Bose? Yes, Pathard, please.
Pathard matter item number 230, 230.
I have given notes. My lord.
Sir, I'm told Mr. Kormakar had started submissions, my lord, on the last occasion. Just to give your lordship a very brief account of what I will be, my lord,
Mr. Chatterjee, Mike.
submitting before your lordship. Microphone take it too.
This is that, the bids.
Yes. Pre-bid amount, which we forfeited. My lord, he participated in the,
Yes.
he participated, my lord, in the bid, in the tender. In the tender, I choose not to answer now, later.
Mr. Chatterjee, are you being collectively welcomed by everybody? Since it's your first day of submissions to the court?
No, they sledge me everywhere, my lord. Even now, my lord, all this while I was being sledged about Siliguri, about Bombay, everywhere, my lord.
Very well,
They do
yes.
it, my lord. They have their.
Yes.
Now, my lord, my respectful submission is that once you've participated in the tender, you have accepted the tender terms. You can't now go back and say that I am not going to adhere to one part of that tender term, which is forfeiture. Now, submission is made by my learned senior friend that forfeiture, since the word liable is used, it means that, my lord, there is discretion. That it's not automatic. That I will have to use discretion whether I want to forfeit or not. Lord, in my respectful submission, Lord, there'll be twofold submission on that. One is, I will try and show your lordship, Lord, that this is automatic. And secondly, if you say that it's discretionary, then there is nothing to show before your lordship, Lord, that I was arbitrary, or I was discriminatory, or I was unfair. Vis-a-vis, Lord, my learned senior friend's client. Lord, kindly sees what my problem is. This is with respect to, my lord, selling.
Mr. Chatterjee,
My lord.
I have heard Mr. Kormakar. Now you formulate your points.
Yes, this is my first point. That, my lord, once you have participated in a tender, you cannot challenge those tender terms anymore. Number one. Number two, once the tender, my lord, is floated and I know and the world knows your bid, at this point of time, if you say that you are not going to, my lord, perform, my lord, the forfeiture has to be, my lord, invoked automatically. Now, what happens is, my lord, once you've given the bid, everybody in this world knows how much you have paid. Now you don't come forward and, my lord, perform your duties. So everybody knows outside, my lord, what is, my lord, the amount which is there, and nobody will bid, my lord, higher than that. And in the process, my lord, that I will be the loser. This is my second point, which I say, my lord, your lordship would kindly, my lord, consider.
Yes.
My lord, kindly turns to first.
Mr. Chatterjee, formulate your points,
Yes,
then
my
documents.
basic points would be on that. My basic point
What
is
is
this:
what is the basic point?
Once you've participated in the tender,
That's your second point. What is
Yes.
your first point?
well, that's my first point. The second point is, my lord, about the invocation of forfeiture. My lord, I say, my lord, it's automatic and not discretionary. Not discretionary. Maintainability of a writ petition, my lord, I'm told my learned senior friend has said that he's not going to press certiorari. Mandamus, I can't say, my lord. Certiorari is not going to press.
You're not going to press certiorari. Is that what you said?
No. Who said so? Sir, no.
Mandamus korbe, certiorari korbe.
No. Did you say that you're not going to press certiorari?
I never said in my note. I have not said that.
So you're pressing certiorari.
Certiorari, the last part, it is a defective portion. Delete that. I said conscionable justice to be rendered. Your lordship read the prayer and said the portion of it is. But both mandamus and certiorari lies. If it is a public law element involved, then writ is maintainable. If writ is maintainable, both lies. Simple. I mean,
So, my lord, may I first understand from my learned senior friend which part of his prayer he doesn't want to rely on certiorari?
My lord, I again said, your lordship, I said that in front of you, lordship read the prayer A, there.
And now,
My lord, it says, a writ of in the nature of certiorari directing respondents to certify and transmit the records of the case so that conscionable justice may be rendered. Stop.
that's it. So the other part, my lord, he's not pressing.
I am not pressing.
Very well.
Conscionable justice.
I've got no
For
problem.
that, my mandamus is there.
Yes.
You have to produce the records.
Yes.
Very well. Then Kali sees the next prayer. A writ of and or in the nature of mandamus commanding upon the respondents, the men and agents and associates, assigns to forthwith resign, recall and quash any order and or order to withhold pre-bid earnest money deposits submitted by the petitioner and consequently refund the same in his favor. So he's basically praying for my lord refund. Forfeiture is not under challenge anymore then.
Why would you say forfeiture is not
Kindly
under
have a
challenge?
look at Pilot, because forfeiture is something that he said in that prayer in B, in certiorari. He used the word forfeit. In this C, my lord, he doesn't use forfeiture.
I have made it wider by stopping there.
So forfeiture, my lord, is not under challenge anymore. Technical, but yes, it is. Now, take
Mr.
it for
Bose,
granted.
Mr. Bose, let the court enjoy Mr. Chatterjee's submissions. All right. You can relax. Yes.
Kindly now turns to my lord the bid document. Kindly turns to it and I'll show your lordship from there. Kindly turns to my lord page 20 first.
Yes.
Kindly sees the bottom.
Yes.
The bidders must satisfy themselves. That's
Yes.
the first part. My lord, kindly got it, Lord?
Yes.
The bidders must satisfy themselves on all aspects pertaining to the nature, quantity, quality, other technical specifications, taxes, duties, and legalities, and any other related matter prior to bidding in the e-auction. No complaint whatsoever would be entertained after the submission of the bid. This is the first point. Then, B, after the submission of bids by any prospective buyer, a presumption would be drawn that the bidder or buyer has inspected the materials and has satisfied himself fully about the nature, quantity, quality, other technical specifications, taxes and duties and legalities prior to the e-auction. No complaint whatsoever on the points referred above would be entertained after the submission of the bid. And this is below a disclaimer as well.
Yes.
My lord, B1 is a little longish. I don't think your lordship would be, my lord, interested in the entire. Kindly comes right at the bottom. So it's a very long sentence. The bidder shall bear all costs. Lordship, kindly got that?
Yes.
The bidder shall bear all costs associated with preparation and submission of his or their office, and MSCC NJMC Limited will in no way be responsible or liable for these costs, regardless of the conduct or outcome of the bidding process. NSCC NJMC at its full discretion reserves the right to reject any or all of the offices or withdraw the bidding process without assigning any reason whatsoever, and in such case, no bidder or intending bidder shall have any claim arising out of such action. No vested right or interest shall be created in favor of the bidders in any manner. This is the other, my lord, caveat. Then kindly, this is the next, very importantly, B3.
Yes.
Submission of bid shall be in accordance with the terms, conditions, and instructions of bid document mentioned herein, after verifying all the facts relating to the contract and after being fully aware of the terms and conditions of the bid document and being fully satisfied to the same. The bidders is debarred from questioning and challenging the terms and conditions of bid document, including its implementation.
So, Mr. Chatterjee, what is the point?
The point is, my lord, that once the bid has been, my lord, he has bid in the tender process. He has given us, my lord, an amount. Once he has, my lord, exercised that right, he can't now today say, my lord, that I can't forfeit it. Because forfeiture
You're
is a
saying it's
part.
an automatic.
Yes.
It happens automatically.
My lord. And he doesn't have a right to question it. He doesn't have a right to question it. He knew beforehand, my lord, it was his duty to check. It was his duty, my lord, to see if everything is, my lord, to his satisfaction or not. We didn't force him to, my lord, bid. He came and bid, and thereafter he can't say, my lord, that I cannot forfeit because he doesn't want to fulfill, my lord, his obligations.
But if I remember correctly, the second highest bidder, I think that person, that entity was called upon after looking at the bid sheets. So what is the extent of loss which you project, loss which you will suffer?
My respectful submission, it's not about my loss or anything of that sort. It's about, my lord, the bid document. It's a right, it's there in the bid document itself, embedded. It's not about my loss. The contract says that you have there are eventualities. The contract says there are eventualities. If that eventuality has happened and that right gives me a right, my lord, for forfeiture, my lord, I am entitled to, my lord, exercise that right. You can't then say that forfeiture, my lord, is discretionary.
But in this case, Mr. Chatterjee, will not the forfeiture be seen as something akin to a claim of damages?
My lord, respectfully submitting, my
Claim
lord,
for damages?
yes, my lord, respectfully submitting, my lord, the nature of the document or nature of the stipulation doesn't say so.
Because Mr. Chatterjee, I don't remember the contract terms or having seen
I'll
them,
show you, lordship.
but it's something like, if you haven't done your work, if you have saved time and resource, if you have wasted my time and resources, you pay up. Or this money we will forfeit, we will not give it back to you. So it's something like damages for non-performance. So if you get that money from somebody else, then what is
Lord,
the loss?
respectfully submitting, it's basically, my lord, the way I see it, my lord, it's basically performance guarantee. Basically, it's not about, my lord, this is not a performance of work, buying and selling. This is basically, my lord, buying and selling. If, my lord, like a development agreement.
Why is it a buying and selling?
That's what the bid about.
They were
Looks
supposed to
my
do
lord,
some excavation work or
nothing,
whatever it
nothing.
is.
They just pick up those materials and
Yes,
sell it,
whatever.
take it away. That's
They
it.
have not done it.
Scrap. Not done it.
They have not done it, and now they want the money back.
They want their money.
And they are saying that we will give you, or rather that this is the projected estimate of your loss or a reasonable estimate of loss, and we will make good that loss in terms of getting somebody else, whatever, and you give back the balance refund.
That's not his discretion. I am not here, my lord, to really adhere to what he wants. My lord, it's my document. I have, my lord, floated a bid. He has, my lord, come and participated. Then he can't come up and say, this is what the terms I have. He can't say, my lord, that I will work according to my terms. He can't say that. My lord, if the document says that you have to perform in a particular way, and if you don't perform, I have a right to, my lord, invoke forfeiture. He can't come up and say that, look here, whatever loss you have, I will compensate. Now, my lord, when the forfeiture happened, what loss I have had today, later, my lord, he doesn't know. I don't know. Because the next person, whether he will work or not, whether he will at all, I don't know. And I'm told, my lord, that nobody has come. The second bidder hasn't come. Because this is all out there in the market now. They know, my lord, what the price is now. If he doesn't work, the next, what will I have to do? I have to go and, my lord, float a new tender. And then, my lord, the price which I will get will definitely not match, my lord, 51.
But didn't
they have not come?
No. Didn't Mr. Bose give some sort of a calculation which takes into account all these contingencies?
Lord, that's his calculation, as whatever he has thought it is correct. That's his terms. I don't want to adhere to his terms.
No, I showed his
I
affidavit.
want to see what he wants me to show me. I don't want to. I am on this document. Lord, he dies, he lives or dies by this, I live or die by this, not by what his perception is. Lord, if I today, Lord, float a new tender because the second person hasn't come.
Yes.
And Lord, the bid comes at 20 crores. I just give you a lordship, Lord, a hypothetical situation. So I lose this money, public money. Public
No,
money.
so that you don't lose it. Therefore, that offer was made.
The offer, my lord, would be pay the 51 crores or whatever crores it is, my lord. I have no problems. You take it away. I have no problems. There's no loss anywhere. Nobody loses anything. My lord, sees the malafide here. He participates. He bids. Moment the bid is over, moment the bid is out in the open, he starts asking for clarifications. Clarify. This is malafide. My lord, all this while, why I showed your lordship the first 2 pages, my lord, was that he had to be satisfied with what he was bidding for.
Clarify what?
That's what is, my lord, why is the walls, why are the walls not, my lord, included? But something as vague as that. I'll show your lordship right away, my lord, what he was clarifying, what he was trying to clarify.
That's fine. Please,
Yes.
please proceed. Yes.
So as vague as that. Why? Because he probably didn't have money. Probably. And if he had money, well, there was no problem in participating, in doing what he wanted to do.
No, we have annexed the bank statement saying that we had full money. I mailed it to them that we have given the money.
David, Mr. Bose?
Yes.
Yes,
No,
yes, Mr. Chatterjee.
My only thing, Millard, I request my learned friend has filed affidavits to stick to whatever has been stated in the affidavit.
I am sticking to
About
what-
their estimation of
No,
loss.
Mr. Chatterjee is wholly depending on Mr. Kormukar, so that's fine. Yes,
No, I'm always.
yes,
I asked him, he said he has briefed him to yesterday.
yes,
No, that's what he told.
yes, yes, Mr. Chatterjee.
না বলেছে নিয়ে এসেছে আজকে তোমার ব্রিফ কালকে করেছে বলেন
Yes.
So, yes. So my lord, I am not even going into my affidavit. What I am stating before your lordship is on the document itself. I am not going anywhere. Mr. My learned senior friend wants me, my lord, to stick to, my lord, my affidavit. I am sticking to his my lord, documents that he's annexed. I'm not going anywhere else. And his documents would show, my lord, that he doesn't have a right to say today that forfeiture will not be invoked. Cannot be. This is what I am on, my lord. This is the start and end of my submission, and this is what I will, my lord, develop before your lordship. That once there is a clause, my lord, at the sake of repetition, once there is a clause of forfeiture, my lord, that there is a clause of forfeiture, you will have to, my lord, adhere to that. You cannot now come up and say that I will not adhere to forfeiture, or I don't have a right to, my lord, forfeit.
Very well. Mr. Chatterjee, when do you want to come back?
Any day, your lordship.
And you conclude on that day.
Yes, yes.
My lord, I appear on behalf of the respondent number 3.
Who is that? Sorry, MSTC,
MSTC.
the platform.
My lord, my instructions are that we are supporting the respondent number 1 and 2's arguments over here. And one thing, my lord, that there were no technical difficulties in the platform. There were no technical faults in the e-auction
Is
platform.
that
of
an
MSTC.
allegation?
He wants to get himself out, I think. That's
And my lord, the only allegation against us is that we have not been able to provide them clarifications. My submission, lordship, is that they cannot, number one, they cannot ask for clarifications after
No,
they
but
have bid.
have they asked you for any clarification?
Yes, my lord, they have asked, and they have also alleged that we are unable to give them clarifications. MSTC as the e-auction platform cannot give clarifications.
What is it, Mr. Banerjee? I thought it's only against Mr. Chatterjee's trial.
against them. MSTC was a disclosed agent who was doing the entire thing. In course of the arguments, it came up that they have returned everything, the bid before a particular date. So
Yes.
that clarification was required, that how have you and when have you given it back? With regard to my writ petition, my allegations are restricted only against Mr. Chatterjee's client. It came up, Mr. Kormukar had argued that we've returned the money, and that's happened through MSTC. So that clarification was required by way of an affidavit, that how did you return it and at what stage did you return it?
Very well. So at this point of time,
I
you
have
don't have
nothing
any.
against MSTC except this. Again, this will become a relevant thing.
Very well. Yes, learned counsel appearing for the respondent NJMC will continue with his submissions on. Tell me, Mr. Chatterjee, first, are you enjoying an interim order, Mr. Banerjee?
Yes, ma'am.
You are. Mr. Chatterjee, when? First week of May, second week of May?
First week of June.
Yes, it has to be a Tuesday or a Thursday.
First week of May.
Lordship, যাবে বলবেন আমার
Yes.
whenever your lordship please.
Yes, yes. List this matter on 2nd May. 2023.
That's the only day on which Mr. Bose is not there.
Allow me to finish. Mr. Bose can, my lord,
List this matter on 4th May 2023. As prayed for, stop. It is further clarified. Learned counsel appearing for the petitioner clarifies that the petitioner does not have any substantial complaint against the platform, namely MSTC.
and also, my lord, he doesn't pray for the second part of
No,
the
my
writ of
lordship
certiorari.
only record that I have no qualms against how the technical aspect of
Very well.
the
Learned
conduct
counsel
of the
appearing
tender.
petitioner submits that the petitioner has not made any complaint against the on the technical working of the platform
That's right.
of MSTC. Stop.
Certiorari, my lord.
No. 4th. 4 তারিখ। Yes, call on the next matter.
রেকর্ড করতে পারবো।
তোমরা তো নিচ্ছ না।
Call on the next matter, please.
Item number 231. Lord, on the last occasion, Lord, we had filed our written notes of arguments.
Yes.
And yeah.
Yes, the notes of the respective, the notes of the parties are before the court. Stop. List this matter
T1.
on tenth May 2023 under the heading for judgment.
I'm grateful.
I'm grateful.
Call the next one. আর কি আছে? তাড়াতাড়ি দেখুন।
232.
232, I'm appearing for the petitioner. There are two matters. One WPA number 28890 Kuntal Samanto. So for that matter is concerned, arguments concluded. We are supposed to file a written notes on that. May I permit?
No, Mr. Shannal, not today. Let me just space out my matters, please. Too many judgments every day. I will take the notes next week.
And so for
Yes.
the second one, I was placing my submissions.
Very well. Mr. Shannal, you tell me next week when you want to come, except for 4th.
Then you'll also
You can come back on 2nd, or you can come back on the week following.
Second, I may come back.
2nd, or come back on 11th. 9th is a holiday.
Any date, except 4th.
Yes.
Not 4th.
List this matter. No, because 4th I've kept a matter. So again, it will be the same thing. I won't be able to hear you. That's why. List this matter on 11th May 2023 to hear learned counsel appearing for the petitioners. Stop. Next.
233.
But I am for the university.
I am for the petitioner. I have almost concluded my arguments.
Yes, but you need to refresh the, I know which matter this is, but that complicated, that amendment and all that, isn't it?
That's there are 3 points. One of the points in regard to amendment, but the other 2 points in regard to the violation.
This is against which university?
Vidyashagar.
Vidyashagar University. Mr. Shannal, I told you, let me release the matter. All these are.
Kindly, so we have placed almost all the arguments,
These are those university that my previous determination. Well, let me release the matter. Why do you want me to hold on? to it?
It's very difficult. We have concluded, so from my submissions here. Kindly, your losses, do not do that.
Yes, yes, Ms. Shengupta, when do you want to come back?
My lord,
I will just hear Mr. Shandal for a wrap up kind of thing, and then I can hear you.
any day, lordship, as your lordship will.
Yes,
please.
this matter was heard quite some time ago. Stop. List this matter on 11th May 2023.
So, my lord, on
Original
that day,
side.
first, Mr. Sanyal will recapitulate.
Yes.
Thereafter, we shall.
Yes. Whatever you're comfortable with. Yes.
But this is in fact
Original.
part matter. Part matter hard on several occasions before my lord.
Yes.
Item number 1, Greenply Industries Limited, West Bengal.
My application. My lord, your lordship was pleased to hear this matter. This is where the MSME arbitration process was challenged by way of a 226. I had almost completed. Your lordship wanted to hear the private respondent and the respondent. I'll indicate the grounds on which I challenged it. That I had filed a 16. There was no communication of any minutes. We were not given any order regarding the decision in the section 16 matter. We were called for a hearing on a particular date. We were not given the minutes of any order. My learned friend appearing for the private respondent, who is the claimant in the arbitration proceeding before the council, had supplied minutes of 10th of January 2023. From that, it appears that my right to file.
So, Mr. Banerjee, there is no award or any decision.
Well,
You are challenging the proceedings.
I was challenging the proceeding. Now this has come forward by way of an order of 10th of January 2023. Kindly just have a look at the last paragraph and I'll sit down. I will not. So my section 16 got disposed of on the same day and I was asked to make submissions on merits. My right to file a statement or a counter statement or a statement of defense was forfeited without giving me an opportunity. There's just a finding that because I have delayed the conciliation proceeding, I am a malafide participant in the process. And now the council has decided that they will issue an award. But at this stage, we had shown the Jharkhand Urja Nigam judgment to show that everything has to be in once there's an incorporation by reference of a statute. The statute steps starting from section 7 onwards will have to be followed, not 7.
18.
18 onwards will have to be followed. Even a statement of claim, counter statement of defense, all that will have to be followed. And then you have to follow the act. This minutes or the order that is recorded here holds that MSME proceeding is distinct and separate from the arbitration proceeding. And on the same day, he goes ahead to dismiss my section 16, forfeit my right of statement of defense, and give an indication that I am a recalcitrant litigant and the award will be passed. But at this stage, I was only praying for a stay of this while your lordship is in CSN of the issue. An award should not be passed against me. Thereafter, your lordship will consider on any day, my lord.
Mr. Banerjee, I must be fair to you so that you can consider that. I have passed a judgment last week, I think. I don't remember when. Must be last week. Hey, Anupam Industries to whatever. The cause title is Anupam Industries. Anupam. ANUPAM. PAM. 25th. 25th of 25th. Yes, 25th. This which is this week.
Very good.
Anupam Industries. Please consider that. Facts are different, but you see the decision.
I'll see that.
All right, because I will have to take that into account anyway.
Lord, my only prayer before your lordship is till we consider that and come back and trouble your lordship again. Till that date, could be tomorrow also, my lord. Will your lordship be pleased to stay their case so they don't pass an award? If they pass an award, then the writ petition goes. I have brought on record a notice of 10th of January 2023, which says they'll pass an award. Now, if the award is
So
passed,
if they haven't done anything till the end of April,
let
they
them
will
say,
not do it.
let them say that they'll not. Lordship keeps it on any day.
Mr. Mukherjee?
Not I appear for the council, my lord.
Yes.
My lord, we have not passed any order. We have not passed any award till now. My lord, it's only an indication that an award has been passed. My lord, and allegations are made against the MSME Council that natural justice has been violated at every stage.
No. Just
At
on the limited, I will hear you.
Mine.
Full.
Mine. We will not
full-
pass, definitely. When your lordship is in scene of the matter, definitely we shall not be
That's enough.
interfering with that.
Mr.
If
Banerjee.
this could be recorded, I have absolutely, this kindly records this, my lord. Kindly.
Your
You are
lordship
for?
may record.
My lord, I beg to appear on behalf of the private respondents, my lord. My lord,
Very well. I will hear you, but just this part. Yes, as recorded in the earlier orders, as recorded in earlier orders, the comma, the petitioner is unhappy with an ongoing proceeding conducted by the MSME Council, capitals, stop. The petitioner claims that the procedure being followed is contrary to the mandate of the MSME Act as well as the Arbitration Act. Stop. Arbitration Act 1996. Stop. Next, the immediate apprehension of the petitioner is that the MSME Council, that the Facilitation Council, capitals, may proceed to pass an order or award which will make the writ petition infructuous. Stop. Next, learned counsel appearing for the council, capital C, CIL, appearing for the council, submits that there is that the council will not pass any decision while the court is during the pendency of the writ petition. Stop. Next, list this matter.
Whenever, my lord. But she keeps it on Monday. I'll consider my lord's judgment and come back and.
my lord, may I humbly submit one thing, my lord? My lord, as per section 18, subsection 5, there is a mandate, there is a provision, my lord, which clearly stipulates that the proceeding before initiated by the MSME Council is to be completed within a period of 90 days, my lord. My lord, I prefer an application before the MSME Facilitation Council back in 2021, my lord. Simultaneously, the conciliation proceeding initiated, my lord. There were 3 opportunities which were given.
No, I will hear you on merits. Yes, learned counsel appearing for the private respondent / supplier.
Supplier, my lord.
Supplier points to section 18 within brackets 5 of the MSME Act, which mandates a period of 90 days, 90 days for the council to pass an award. Does it say award or order?
My lord, may I read it for my lord? My lord? Every reference made under this section shall be decided within a period of 90 days from the date of making such a reference.
Yes, which mandates decision in a reference within a period of 90 days. Stop. Council submits that the respondent made an application before the MSME in 2021, before the council in 2021. Stop. Next,
I could respond to that in a minute.
Yes.
Well, the reference started in July. He can't argue this today.
Of
July of 2022.
Very
90 days.
Council appearing for the petitioner submits that the reference actually started in July 2022. Stop. Next, in any view of the matter, this point will also be taken into consideration. Stop. list this matter on 3rd May 2023.
Noted.
Grateful, Your Lordship.
Next.
Item number 2, Swarnoti Mahapatro.
For the respondents. The last day also, my lord, this matter was taken up. Mr. Banerjee was addressing my lord. This is a writ petition wherein, my lord, the petitioner has, my lord, challenged the order
Yes,
of
no one appears for the petitioner.
last day also, my lord.
Stop, list this matter on, tell me, Mr.
Any day as
Tiwari,
per
when you
my
want.
lord's, my lord. But this is infructuous petition. Whenever, my lord, my lords keep, my lord, we don't.
No, you were being led by Mr. Banerjee.
Mr. Banerjee, sir.
So no one appeared for the petition on the.
But that day also, my lord, no one.
No, this is a second time when the petitioner is not represented. Stop. WPO 564 of 2023 is accordingly dismissed for default. Interim orders, if any, shall stand vacated. Next.
Deeply obliged.
3, Banwarilal Jajodia.
My lord, I appear for the petitioner, my lord. This is, my lord, against an order of review committee declaring me a willful defaulter, my lord. My lord,
Yes.
the 4 points on which, my lord, I have approached this honorable court is: 1, my lord, the jurisdiction of the review committee, my lord, the order apparently, my lord, is signed by, my lord, Chief General Manager, my lord,
Yes.
which is, my lord, contrary to the review committee's constitution, my lord. My lord will find the signature at page 68, the last portion of the order. That's the first point, my lord.
Yes.
The second point, my lord, is this, my lord. The show cause notice, my lord, proceeds on the premise that I have diverted funds, and the, my lord, the date of diversion of funds is of year 2017 and 2018, whereas, my lord, the NPA, my lord, was of year 2012 and 13.
What
Non-performing asset, the declaration of my account as a non-performing asset was in 2013, my lord. My lord, so my respectful submission is, my lord, the acts which allegedly constitute willful default cannot, my lord, happen after the default. The default happened in 2012, and the allegations of acts constituting default is of 17-18. On the face of it, does not, my lord, conform to the requirements of the willful master
You're
circular.
saying that after being declared an NPA, they are saying that you have committed willful default. Very, very well.
That's the second point, my lord.
Yes.
The third point, my lord, is that, my lord, they have, my lord, we are the guarantors, my lord. The principal debtor was a
How many petitioners?
Well, petitioners, my lord, are well, there are 3 petitioners. 3 are at page, my lord, 1, my
Yes.
lord. My lord, these all 3 petitioners are guarantors, my lord. The principal debtor was a company which went into corporate insolvency resolution process, my lord.
So all 3 were guarantors?
Yes, my lord.
Yes.
Now, my lord, the company went into insolvency, my lord, and, my lord, the company was, my lord, in fact, my lord, has been taken over by a successful resolution applicant under the aegis of the National Company Law Tribunal, my lord. Now, my lord, under the resolution plan which was approved, my lord, the banks, my lord, including the respondent bank, my lord, has assigned, my lord, their entire residual debt to an NBFC, my lord, against consideration of certain sum 33 crores, my lord.
Yes.
So, my lord, I say, my lord, this is clearly in violation of Master Circular, my lord, clause 2.9, which says, my lord, if the bank, my lord, settles or compounds their debt, my lord, and receives consideration, my lord, then, my lord, they cannot maintain, my lord, any action for willful default, my lord. And I'm covered by my lord's cases, judgments on this, my lord. So, my lord, they have, on the one hand, my lord, once they assign their debt, my lord, they do not remain my creditor. My lord, my creditor is the assignee, my lord. So then they cannot proceed to declare me as a willful defaulter because they no longer are my creditor. Maybe the assignee is. That's my third point, my lord. And the fourth point, my lord, is that, my lord, proceeding under section 95 for declaration is already pending and moratorium is in place, my lord, so as I'm concerned.
95
of the Insolvency and Bankruptcy Code
Yes.
for declaration of personal guarantors as, my lord, bankrupt, my lord. So that proceeding is pending, and, my lord, before the NCLT, my lord. That's the fourth point, my lord. So these are my 4 major points, my lord. May I now, my lord, take, my lord, to each of those, my lord, with the documents, my lord.
No, what is the interim relief you want?
Interim, my lord, I don't think there's an interim relief. My lord, I have been declared, my lord, I have to contest. So I have no interim relief as
Do
such.
you want to file an affidavit or should I just decide it?
No, my lord, we would be filing an affidavit. We would require to file an affidavit.
What, how are you? Has the debt been settled or not?
No.
Yes.
No. Microphone,
I'm sorry, it's on. Yes,
Yes.
that has not been settled.
not settled.
Not settled, and there was the
So
violation
not
is.
assigned to an NBFC.
But at the time when the violation had taken place, then it was not assigned. And my lord, also, my lord, the argument is that, my lord, or the case taken in the reply to the show cause notice is that the transfer which was made by them in willful default, it's from an account which is part of the TRA account. But we have that agreement also, the consortium agreement, which says that bank from where the transactions were made were not part of the TRA. So there's a violation of that and violation of specific, my lord, clauses of the, my lord, willful defaulter guidelines. So, my lord, after everything, after these acts of,
But what does clause 2 say? That once a debt is settled, then you can still proceed.
My lord, I would be relying on two judgments, my lord, of the Supreme Court and also, my lord, of one of our High Court, where it says that in spite of the fact that the principal debtor might have, my lord, against that a CIRP may have been initiated and a resolution plan may have been approved against the personal guarantors, still that would continue. But what our arguments were in one of the matters, my lord, that it's coextensive. So if one is gone, then the question of the guarantors cannot go. They are in the same shoes, so they'll also have to go. But that was negated specifically. And, my lord, after that, my lord, the Supreme Court judgment has also come that we can proceed separately against the guarantor, irrespective of the fact that whether the principal debtor has gone into CIRP and whether a resolution plan has been sanctioned. So, my lord, relying on that, my lord, the bank
Very well.
is,
How much time do you want for your
my
affidavit?
lord, 3 weeks if your lordship permits.
Where is the impugned decision?
My lord, it's page, my lord, 55, my lord. And my lord will kindly see page 68, who is signatory, my lord, the Chief General Manager.
What is the date of this?
My lord, the date is 29th August 2022. My lord will find it page 68. 29th August. But this on the face of it, my lord will kindly see page 68. The review committee must be headed by chairman, my lord, and 2 independent directors. But this apparently this order has been passed by a Chief General Manager, page 68, my lord.
Very well. Learned counsel appearing for the petitioners submits that there is no scope for an interim order. Stop counsel, however, takes the point of jurisdiction of the review committee in respect of the signature of the Chief General Manager of the NPA Management Group of which bank is this? Of
IDBI.
Of IDBI.
IDBI Bank.
Writ lies. IDBI.
No writ lies, but in two matters, my lord, we have got that judgments in our favor that writ doesn't lie. In 2 others, so my lord, I myself appeared in 2 matters where the writs were dismissed, and in 2 matters, despite showing that. So my lord,
My lord, there is a recent Gujarat High Court judgment on same point, my lord.
Very well. I'm keeping that point open.
Yes, kindly.
Yes. Ki bola? Yes, the impugned order declaring the petitioners as willful defaulters is dated 29/8/2022. Stop. And the petitioners have come before this court in March 2023. Stop. Next, affidavit in opposition by 15/5/2023. Reply within 1 week after the vacation. Stop. List this matter on 14th June 2023. 15th May 14 June 2023. Stop. The point of maintainability is kept open.
Lord, may I file the affidavit of service, my lord?
The affidavit of service is kept on record.
Item number 4, Ashu Dhar versus the Assistant General Manager, UCO Bank. Lordship, may I please your lordship?
Yes.
Lordship, the petitioner before your lordship participated in the e-auction of the respondent bank on March 23, 2020 and was declared as the highest bidder. Lordship,
Affidavit of service.
Yeah, lordship.
Sixteenth March, you served them.
Lordship.
16th March. What is the interim order you want?
Lordship, not interim order, despite declaring as the highest bidder and tendering of the entire highest bid amount, the petitioner was neither given the actual physical possession nor the amount which he had tendered. Lordship, kindly come to page number 11. This is the sale certificate issued by the respondent bank in favor of the petitioner. Lordship, prior to this, kindly come to page
What is the date of this?
Lordship, this is dated at the bottom, Lordship, 6th of April 2020.
Yes.
Lordship, upon issuance of this sale certificate, series of correspondence was made. I do not want to waste your lordship's precious time. Kindly straight away come to page number 15.
This is impugned.
No. This is my demand justice notice.
Yes.
Lordship, kindly allow me to place under instructions from and
No, not the whole thing, just the relevant paragraphs, please.
Lordship, kindly come to second paragraph. Pursuant to participation in the e-auction on March 22, 2020, in terms of your sale notice dated such and such, my client was declared as the highest bidder in terms of your communication dated such and such, and in connection therewith, he tendered the sum of rupees 17 lakh to you, and upon payment thereof, self-confirmation advice dated such and such was issued from your end in favor of my client. It is quite unfortunate that till date, physical possession of the secured asset is yet to be delivered to my client. In view of the above, you are requested to hand over physical possession of the secured asset to my client within 3 days from the date of receipt of the instant communication, failing which you may return the said sum of rupees 17 lakh to my client along with interest at the rate of 14% till the date of actual payment. Lordship, this was received. Kindly turn over the next page, page number 16. It was received by the respondent bank on 3rd of March 2023. Page number 16, the track delivery report. Lordship, petitioner.
You're the auction purchaser?
Lordship.
And the affidavit of service is kept on record. Next, the petitioner claims to be the auction purchaser of a property which was mentioned in a sale notice issued by the bank dated 21/2/2020. Stop. The sale certificate dated 6/4/2020 is on record. Stop. The petitioner claims refund of the amount put in by the petitioner of 17 lakhs along with interest, since the petitioner complains of not being given physical possession of the secured asset till date. Stop. Next. List this matter. You have to inform them, communicate this order on them and come back. When do you want to do that? List this matter on 3rd May or the week after that?
Lordship, kindly take it up on 4th, subject to lordship's convenience.
4th will be a short list. List this matter on 4th May 2023. As prayed for, the petitioner shall communicate this order on the respondents.
I'm grateful, Lordship. Item number 5, Uma Mitro.
Item 5, I beg to appear for the private respondents.
Your Lordship, the pleading counsel, he's suffering from cancer, Your Lordship. He's going through his treatment. We are seeking for a day's adjournment, Your Lordship.
Suffering from cancer?
Yes,
Then
Your
how will he appear tomorrow?
As per his instruction, Your Lordship, he said that he won't be able to come today.
Who is the pleading counsel?
Arnab Shaha, Advocate Arnab Shaha.
Yes, adjournment is prayed for on behalf of counsel appearing for the petitioner. Stop. List this matter on 3rd May 2023.
Oblige, your lordship.
Item number 6, Pranab Bose.
Mr. Jishnu Chaudhary is appearing for the petitioner in this matter. He has left court. He was not feeling well. If Milord kindly.
Same order. Should the list this matter on 8th May 2023. Is it urgent?
Yes, Milord, there are some urgencies with respect to it.
Third. Next.
Grateful.
7, Shorjo Das.
Lordship, Mr. Kajal Roy is appearing in this matter on behalf of the petitioner. He left court due to personal difficulties. Kindly grant not today.
Act order 8th.
Item number 9, Somabrata Mondol. 8. Item number 8, Continental Chemical Corporation.
Yes.
Judgment of the judgment of
Mr. Kaur and Mr. Pincha, I couldn't go through the notes. I didn't find the time. So I will keep the matter in the coming week and then make it reserved for judgment. All right. And you don't have to come to the court, Mr. Pincha. You can, it's fine. I will just make it reserved for judgment and indicate the date in my order.
Your Honor, my learned friend Lord handed up Lord judgment on the last occasion.
Yes.
That is Lord reported in 2021 SCC online Supreme Court 972.
Yes.
That's a reported judgment. May I hand up a copy of the reported judgment?
Yes, yes, of course.
But if your lordship looks at paragraph 3.
No, just 1 minute. What was the paragraph you relied on? Mr. Kaur, first tell me that and then I can put it.
My learned friend relied on paragraph 48.
48?
Oh.
No, 9.2.
9.2, yes.
9.2. Where do I find that?
Is equivalent to paragraph 48.
48?
Yes.
Very well. And what is the point, Mr. Kaur?
Lord, the point is your lordship will get the facts from paragraph 3.
Yes.
It was a voluntary retirement scheme which was floated by the company.
Yes.
And Lord, it was supposed to be extended to all. That is the issue. That is the issue in the judgment. Paragraph 48
Yes.
and then paragraph 49. Lord, that also is important.
No, what was the point for which the judgment was cited?
Judge, I really don't know. He is trying to say that there is discrimination as between the lessees in the industrial estate.
Yes, yes.
This I have dealt with, Lord, in my notes. And Lord, the instance that he has given of a particular farm, that farm, no lease has been executed by the West Bengal Small Industries Corporation because they failed to comply with the terms. That I have also indicated.
Very
Your Honor, after they conclude on the next date, I'd like to say just a few words and then, if you'll permit me.
Only because you're appearing in person, I'm giving you that liberty.
Thank you, Your Honor.
Yes. A learned counsel appearing for the petitioner appearing in person seeks to make short submissions in response to the case made out by the respondent. Stop. List this matter on 8th May 2023.
Thank you, Your Honor.
Mr. Kaur, 8th May is all right with you or?
Absolutely.
Rising, my lord. Before rising, my lord, item number 2, Mohim Sasmal is appearing in this matter, lordship. His mother was expired on yesterday. So
item number 2 in original side?
Lordship.
কি করেছে item number 2 তে?
Dismiss for default, lordship. Kindly.
Very well. Dismiss for default করেছে ওটাকে orderটা when do you want me to keep the matter?
Next time, lordship. In the meantime, ritual has been completed, lordship.
Item number 2 টা dismiss for default টা কেটে দাও। Give me a date in second week of May or after the holidays.
Second week of May, any date, lordship.
Yes, list this matter on, no one appears, no, কেটে দাও। List this matter on 16th May 2023.
Correct, lordship.
May it please your ladyship.
No.
जी,
Respondent appear coach, respondent with